Testing. Okay. Wanted to make sure we had sound. So. I don't think she's going to be on today. So. Oh. Does it get lost?
Yeah, I was sitting there doing collection stuff. I was like, this don't look like me.
I didn't know all this was you. I knew they built out that built out, but they didn't build the top.
I heard they
They're attractive.
Yeah.
Well, everybody else is done. I think Jennifer's in the waiting room.
All rise. Chancery Court of Cheatham County is now in session. Honorable Judge David Wolf presiding. God bless the courtroom. Great state of Tennessee. God bless the United States.
Sally, did you unmute us?
Be seated, please.
Good morning. I'm going to take up a Chancery matter first that we have some urgency to. So, all right, Ms. Roberts, if you can hear me, I need you to, I don't know if you need to start your video or if you just need to make sure you're unmuted, but my understanding is that we have some matter in the Justice versus Justice case I need to address. All right, this is your motion to withdraw, Ms. Bloodworth.
Yes, it is, Your Honor. Thank you. This is a divorce matter, and there's nothing pending. There's not a final hearing set. And we have a fundamental difference on how to proceed, and that's the basis of my motion to withdraw. I did notice up my client for 9 a.m. I don't see him here. I did check with the other in the other courtroom, and I did not see him here. I did tell him his presence was necessary. And Ms. Roberts may want to be heard as well.
Ms. Roberts, you have anything to add to this?
Yes, Your Honor. I just want the record to be clear about the fact that Mrs. Bloodworth and I had this matter scheduled in front of Judge Turnbow on some various motions that I had filed. We had gone back and forth with our clients, and we had reached an agreement that I had typed up on my computer. We asked Judge Turnbow to take a recess so that we could go over the order. We thought it would be more expeditious for us to use the courtroom, have them both sitting there for us to go over the order to make sure both of them understood what we were entering into court. Judge Turnbow was gracious enough to leave the bench, and we started to, and I was reading over the order to both of our clients. Mrs. Bloodworth's Mrs. Bloodworth's client, Mr. Justice, became verbally combative. He hurled a number of insults, personal attacks at me, to the point at one point in time, he actually asked me to come and let's take this outside and settle it. At that point in time, I asked the bailiffs to come back into the courtroom. The clerk, as well as our court reporter, are all witnesses to the actions of Mr. Justice. He became verbally combative with his attorney, making comments to her. We had the court designated accountant there, and he made comments to her. And so it was a very inappropriate situation to take place. In hindsight, I probably should have asked that he be arrested for the threats that he made towards me personally, but it was a extremely bad situation. I have contacted the Board of Professional Responsibility over what had transpired, just to get guidance as to the fact that the actions that Mr. Justice displayed in court personally against me, whether or not it was a situation that I became a hindrance to my client, and because he had attacked me personally about things. And so I'm waiting on an opinion on that, but I just don't see it. Again, Ms. Bloodworth has justifiable reasons to withdraw because of her client's actions.
Your Honor, if I may, the depiction of events is accurate as described by Ms. Roberts. I wanted to have that on the record as well. And I have an order for the court's consideration. I don't know how many days Your Honor would allow him to retain new counsel. I did leave that blank.
Well, we'll give him, I normally provide 30 days to retain new counsel, so I'll add that.
Yes, sir.
Ms. Roberts, if you determine from the Board of Professional Responsibility you have the duty to withdraw, then you just simply file your motion and submit an order.
Yes, Your Honor.
Ms. Bloodworth, I have granted your motion to withdraw.
Thank you, Judge.
Thank you, Your Honor.
And that is all we have for Chancery at the moment. We have 10:30 for Chancery. That's correct. Thank you for coming up. Okay, welcome to the Circuit Civil Docket Call for Cheatham County in our brand new courtroom. First time that we'll have held the Circuit Civil Docket Call here, and so we're thankful for having such a nice courtroom. I told somebody the other day that I felt like I was on the bridge of the Starship Enterprise when I sit behind this desk and in this chair, but I'm thankful that we have a better sound system and a better lighting and so forth. I love the old courtroom, but it is difficult sometimes to conduct business because of the acoustics, if nothing else. So we are ready to call the docket, so you may call the first case. That's on the state of Tennessee on behalf of the Commissioner of the Department of Transportation.
Mr. Todd had contacted our office just a few minutes ago and said that he was not aware that he had to appear today and would not be able to speak.
Okay. It's just a review on an agreement. As far as I'm concerned, you can set it for your next civil.
There is another one behind that. It's 6855.
State of Tennessee Department of Transportation versus Judith A. Garcia Alvarado. Motion to substitute the defendant Cardinal Financial Company LP to PNC Bank. Anyone here in opposition to that motion? No opposition, we'll grant that motion. You can reset the review if you want to for next circuit civil docket call.
Docket number 6966, Ruben Vega versus William Lane et al.
Yes, Your Honor. Dale Crowley, Nashville Bar. We imagine that will be 10-15 minutes of argument.
All right, let's take it up.
In the response and opposition. As to the undue delay, Your Honor, which is the first factor, this is a double-edged sword for plaintiffs. We've had about a dozen of these motions already this year, Your Honor, where trucking companies are opposing our motions to amend to bring more additional claims and direct negligence claims against trucking companies. On one hand, if we bring it too early, we get a response saying that there's not sufficient enough facts for this amendment, that is futile, and that there's been no notice of these types of amendments. Well, at the same time, Your Honor, if we wait too long, we receive a response that says that there's been undue delay and prejudice because we haven't brought it soon enough. So, Your Honor, we're trying to find that sweet spot where we can bring these motions with enough facts to actually make a valid, cognizable claim, while at the same time having these granted. So, Your Honor, the facts that we discovered were in December, so we filed this motion about 4 or 5 months after we received the discovery responses. It was originally our plan to do the party depositions to get this sworn testimony into the record to further support our motion to amend. Since it was taking a little bit longer to get those depositions set, Your Honor, we made this motion just out of an abundance of caution to get the punitive damage claim in the complaint. So, Your Honor, as to that factor, we don't believe there's been any undue delay. The second factor is a lack of notice to the opposing counsel, Your Honor. Respectfully, the information that we are pointing to, the factual information for these claims, were in the defense sole control. That they knew that they had already hired this driver, fired the driver, and then hired him again before this collision. So we don't believe that there's any lack of notice about the facts underlining our punitive damages claim. As to bad faith, Your Honor, there was not a argument presented in the response about bad faith. There is, I believe, a one sentence explanation saying that due to the undue delay, they allege that there could have been bad faith behind the scenes of why we were waiting to make this amendment. So I figured I would address that, Your Honor, but as a factual basis, there's not really anything pointed to us that we have acted in. As to repeated failures to cure prior deficiencies, Your Honor, like I said, we have had one prior amendment. It was 2 weeks after our original complaint, just to correct the names of the parties based on that police report. So we don't think that we have had repeated failures to amend our complaint. As to the undue prejudice that is addressed in the response, Your Honor, there is no prejudice to opposing parties here. We are early in discovery in this litigation. There is no trial date set. We have not taken party depositions, and written discovery is still open. So, Your Honor, because of that, we would argue that there's no undue prejudice if this motion is granted and we get to do some additional discovery on that punitive damages issue. And then as to futility, Your Honor, we do believe that this punitive damages claim has weight, that a jury is going to be able to hear these facts and determine if this defendant company consciously disregarded the threat of having this driver on the roads. The argument against us on this one, Your Honor, is going to wait. Opposing counsel has claimed that the facts as we know them right now are not enough to have the jury award beyond clear and convincing evidence for punitive damages. As Your Honor knows, the reason we have discovery is to find additional facts and support that claim. Since we're before the party depositions and more written discovery about this specific punitive damages claim, we think that even at this point we have a good claim, and that it's not going to be futile when more discovery is able to boost up our claim for this, Your Honor. So for those reasons, we would ask that the motion to amend be granted.
All right, from the defendant.
Your Honor, Corey Chilwood here for the defendants. I just want to point out initially the dates of all these things. Defendant Beacon submitted its discovery responses on December 18th, 2026. Then 5 months later, plaintiff filed the current motion to amend on May 13th, 2026. That's about 5 months, and we submit that that's undue delay because in the Bodine case submitted in our response in opposition, there was a 4-month delay that was found sufficiently long enough to find undue delay. And the Tennessee Court of Appeals has repeatedly emphasized the necessity for efficient, speedy, inexpensive resolution of cases. And under the futility factor, which I would believe is the second most relevant factor here, I think it's important to highlight that the Tennessee Court of Appeals has defined futility not only as where it would not withstand motion to dismiss for failure to state a claim, but also where granting the amendment would prolong the litigation but not lead to ultimately to a different outcome. Here, we're litigating the issue of amendment. Then we'll be presumably conducting discovery on the issue of punitive damages, even though punitive damages, in our opinion, would not get to a jury in this case. Part of the basis for plaintiff's motion to amend is that defendant, the driver, was exceeding the speed limit by 8 miles per hour. And then insofar as plaintiff relies on the fact that the company hired the driver after previously suspending or terminating him, I would say that there's just that fact alone doesn't necessarily give rise to a claim of punitive damages. Plaintiff also has to establish the intent required for punitive damages. And here it looks like the intent they would be relying on would be intentionality or recklessness. But simply hiring someone that worked for you before or speeding 8 miles per hour over the speed limit is, Your Honor, I don't think gives rise necessarily to an inference of recklessness. As far as prejudice goes, allowing punitive damages to proceed opens the door to invasive discovery of financial information. Both defendants that really probably is not relevant to this matter and could be used in bad faith. And based on the facts that were available to us and the time span that's occurred, 5 months between the submission of our discovery responses and the filing of the present motion to amend, we didn't really have notice that there would be a punitive damages claim here. And so because of those three factors, namely undue delay, the futility, and lack of notice, we would submit that plaintiff's motion should be denied. I also want to note that there's no hardship to plaintiff if this motion is denied, because if more facts come out in discovery that would give substantial weight or noticeable weight to a punitive damages claim, he can remove to amend. Like you said, depositions haven't occurred yet, so if something were to come up there, they can still, move to amend based on any information that comes out there. And also, it's denying the motion to amend doesn't preclude compensatory recovery for plaintiffs. So there's not substantial hardship on plaintiff if the motion is denied.
How is your client prejudiced if this were to be granted at this stage? I know you said that there was no notice, but I think, go ahead.
Yes, Your Honor. So if you'll allow me, he was kind of talking about their MO, things that they typically deal with in these cases with the trucking companies. So in my experience, once this punitive damages claim is allowed to proceed, plaintiff's attorneys like to submit discovery requests probing financial information, which can be particularly invasive. And so I would submit that would be the primary basis for prejudice in this case.
So if I allow them to amend their complaint, but put an order down that says they cannot submit financial information, financial discovery to your client to prove on the damages part of it, but they can amend it, and then we get to the point where the only time that they would be able to get the financial information is if they can show or sustain a motion for summary judgment or a motion to dismiss. Does that make any sense to you?
Yes, sir. You're talking about placing conditions on the amendment?
Right. I'm just saying, if I granted their motion to amend, but prohibited them from submitting discovery requests on the financial aspect of it to protect your client's financial until there's established a sufficient basis for a belief that there is a claim for punitive damages. I mean, obviously, before you get to a jury, you're going to have to, if the punitive damages claim is sustained, then you're going to have to allow them to have that kind of discovery. But I'm just suggesting, because you say it's early on.
Yes, Your Honor. I think that would substantially mitigate the prejudice if that condition was placed, yes.
Are you okay with that?
No objection from us, Your Honor, on that issue.
Seems to me that's the logical way to do it. I mean, we are operating under a system that we liberally grant motions to amend, and I think the first motion to amend, as was pointed out, was done before any defense counsel was present in the case. And under the rules, they had a right to amend it before a responsive pleading. Now, I'm going to grant this second amended motion to amend, to allow them to add the punitive damages claim, but put a restriction on their claims or the discovery request as to any financial matters until they obtain leave from court to pursue that. And what that means is it gives you an opportunity to do the discovery regarding whether there is a basis factually to sustain a claim for punitive damages. And only after that is demonstrated to a court. It doesn't have to be me, but it could be any of the judges. But once that has been established, then you can do your discovery if necessary.
All right. Thank you.
Thank you.
Thank you, Your Honor.
You're going to draw the order for me?
Yes, Your Honor.
Right. Excuse me. All right, call the next case.
Docket number 7044, Delano Wayne Creel versus Anna Cabana and
Good morning.
Good morning, Your Honor. This is an appeal from General Sessions Court. I represent the plaintiff in this matter.
All right, so this is basically an appeal that's here today to get a date for a hearing.
Your Honor, I believe we're going to need to engage in some discovery. So if we could set a review date sometime in the future so we could.
You want to set it off a ways to do the discovery? Is that it?
Yes, Your Honor, please.
Does it matter who hears? Any of the judges have a conflict?
No, Your Honor. Not from the
How long
plaintiff's.
do you think it's going to take to do your discovery?
There's been no discovery in this matter prior to. I would think somewhere between 60 to 90 days would be reasonable, but I expect a couple of depositions and some requests for documents, so I could have that done within 60 to 90 for sure.
Well, we rotate in here every 4 months. So
Okay.
if you're wanting,
So we'd look 4 months out then.
I'm here in November, correct? And who's here in December? So you got me in November and Judge Wallace in December.
I'm out of the country in December, Your Honor, so the second works great for me.
That date looks great, Judge.
How long do you think, once we get into it, how long is it going to take to try this case?
A day.
Maybe half to a day,
Half a day?
or up to a day, probably max.
Well, that would be normally on the second day of November, which is our circuit civil docket call, and we would just take it up after the. Does that work for you?
Yes,
So
Your Honor.
9 a.m.
9 a.m.
around 10ish probably.
Well, it'll be following. It's 9 a.m. following the call of the civil docket, and then it'll be the first contested case. I know we're going to have to let them know they can't set very much. So, thank you. All right, we'll set it for 9 o'clock on the November the 2nd.
Thank you, Judge.
Thank you, Your Honor. I have nothing further. May I be excused?
You may.
Thank you so much.
All right, call the next case.
Docket number 7054, Pleasant View Utility District of Cheatham County versus John Edward Henderson and Megan Elizabeth.
This is a petition for land condemnation.
Yes, Your Honor. And I represent the Hendersons in this matter.
And I'm Dewey Branstetter, and I represent Pleasant View Utility District. And we have reached an agreement on possession, and we anticipate submitting in the next couple of days an agreed order of just as to possession, not as to the damages for the property. But we've worked it out, Ms. Snow and I have, and so I think we'll be able to submit an agreed order.
Okay, you're just going to submit an agreed order then.
Yes, Your Honor. And my clients are still here, so if I could just make a brief announcement
Sure.
Sure, yeah.
as to their agreement. We are going to agree to the 20-foot permanent easement on the 10-foot temporary easement. We're going to agree on that. However, there is a septic line that is located in part of that area, so the 10-foot will only be the area where the septic is not located. And there will be a 5-foot clearance on around that. And then we also talked about a 5-year warranty to ensure that there's no damages to the septic. And then we're going to put some kind of self fencing around the septic area. And then we'll just reserve any compensation and damages for
All
later date.
That represents the agreement, and I'll approve that agreement.
Good.
All right.
We'll submit an agreement order.
Thank you. Mr. Branstetter, you have a next one as well.
I do, and I'll, if I may, this is Amanda Hoffman, which is case number 7055, also a condemnation case that we're here for possession on. Ms. Hoffman has not responded. She did not respond to the initial inquiries from the district. In fact, Mr. Stephen Ayers, the general manager of Pleasant View, is here. We then filed a lawsuit, petition for condemnation. It was served on her on June 3rd. She did not respond to that. I sent her a copy of the short memorandum that was submitted to the court last week. She did not respond to that. We don't anticipate that she will ever respond, but more than 30 days has passed. And so under the condemnation proceedings,
You're entitled to possession.
we're entitled to possession. I've submitted a proposed writ. I've also got one here that I could then actually serve on her today. The one that I submitted was just a proposed writ, but I've got the same document, an original, if Your Honor prefers that.
As a matter, I've got the one that you had submitted as a proposed. If you have the original, you can submit that to the bailiff.
Yes, I'll submit that to the bailiff, and then I will send her a copy. Let me go ahead and sign the certificate of service, and I will do that today, Your Honor.
All right.
And it's just a proposed writ of possession that allows us the right to enter her property, and it's for the purpose of constructing a water line. And Your Honor, the urgency, the reason we went ahead and filed these condemnation petitions is originally the district Pleasant View had anticipated being able to put the water line in the right of way. As it turned out, there were other utilities, AT&T, Comcast, and so it was not possible to get it in the right of way. So they needed private easements. They're under a time crunch because they've got ARPA, American Recovery Plan Act money, that they have to do this work before the end of September. So that was the urgency for filing these petitions.
All right. Well, I've signed your order.
Good. And I
Thank
will send her a copy and appreciate it. Thank you, Your Honor.
Thank you. Go ahead.
Docket number 6682, Cordova versus Robert Martin.
Good morning, Your Honor. It's ready for argument.
All right.
Discussion. Your Honor, respectfully, I filed our motions first. I think the plaintiff should be heard in this matter first.
You filed yours first, and you may go first.
Thank you, Your Honor. Your Honor, this morning, I think the best way for us to handle this, there's 4 separate matters on behalf of the plaintiffs and 4 separate matters that have been filed by the defendant, Mr. Martin. We would state that on March 3rd, 2025, this court gave Mr. Martin exactly what he asked for, the deposition of Ms. Cordova before any ruling on our pending summary judgment. For 13 months, Mr. Martin did nothing. The only thing that woke this case up was plaintiff's recent motion, noticing their renewed motion for the hearing on the summary judgment that's been pending since March of last year. 16 days later, a single envelope arrived at my office via U.S. mail containing a deposition notice for Ms. Cordova, written discovery and a scheduling motion, and a motion to disqualify all of Ms. Cordova's attorneys, including myself. Every motion that Mr. Martin brings today through Mr. Olson is a piece of that same package, and it has one purpose: to make sure this court never rules on our motion for summary judgment. This case was filed in December of 2020, and the Cordova family, a widow and 2 children, is entitled to a ruling. The basic issue before the court is that Mr. Martin asked for discovery. He was awarded and got the discovery, and then he abandoned discovery. The first I want to state is that there's a motion by the defendant to continue this hearing. Procedurally, that's dead on arrival. There was no accompanying affidavit filed under Rule 5607, and that states that relief is available only, quote, should it appear from the affidavits of a party opposing the motion, end quote. Mr. Martin filed a motion in a memo signed by his attorney, but no affidavit from anyone. That alone ends the inquiry under 5607. The premise is also false. Ms. Cordova did not fail to appear without justification. Rule 3704 states that non-attendance may be excused where a party has, quote, applied for a protective order as provided by the Rule 2603. The plaintiffs here have obviously done exactly that, and the motion is before the court today. The deposition notice itself for Mr. Olson was defective and unilateral. It was served by U.S. mail only. Later on, I will say, just before this hearing, he did follow up and send an email, but this has been a recurring problem where Mr. Olson will not send us emails, and he sends us the motions via mail, even though we've asked for this repeatedly since the beginning of litigation. He set the deposition of Ms. Cordova at his own office in Clarksville. He did it on a date the plaintiff's counsel was unavailable, and he had made zero effort to confer. Fourth, any discovery deficiency is entirely self-created. 13 months of total silence after this court granted his request in March 3rd of 2025. And respectfully, Mr. Olson nor his client can manufacture a Rule 5607 continuance out of their own delay. And we've cited in our briefs the Rye case, and that the focus is on the evidence actually presented, not hypothetical evidence. We also cite the Bird case that requires an adequate opportunity for discovery, but he had 13 months plus the original 5.5 years this case has been pending. His own filings also contradict this claim that the need for this deposition is essential. Mr. Martin's May 2026 filings say Ms. Cordova, quote, had no real involvement and, quote, suffered no money damages. That Mr. Martin cannot simultaneously claim her testimony is essential and then and that our renewed motion for summary judgment just rests completely on his admissions, not her testimony. Nothing she says can unadmit them. Fourth, defendant's motion to disqualify defense counsel under Rule of Professional Conduct 3.7 is unavailable and should be denied. The threshold rule of Professional Conduct 3.7 is a trial rule, and it states, quote, a lawyer shall not act as an advocate at trial, end quote. It does not bar pretrial or motion advocacy, and whatever else happens, counsel may argue every motion today. The disqualification is a drastic remedy granted with considerable reluctance only when no other practical or alternative exists, end quote. And we're citing the Cars LLC versus Ogle case, and that's found at Tennessee Appellate Lexus 140 at page 32. That case really represents the movement. Mr. Martin bears the burden of proof, and courts will scrutinize late tactical motions like this one with particular care. And it was only filed in response to our effort to renew our motion for summary judgment. But practically speaking, no lawyer here for Ms. Cordova is a necessary witness. Testimony is only necessary if it's material contested and unavailable or unobtainable elsewhere. The dispositive facts for the plaintiff's case for for our motion for summary judgment come from Mr. Martin's own sworn deposition admissions, and that was during his November 23rd, 2021 deposition. And we've cited in our brief that those are pages 151, lines 16 through 23, page 153, lines 2 through 16. where he states that under Rule 1.5C and 1.5E, he committed ethical violations. B, the Court of Appeals, their findings, they found that he had abandoned and that the plaintiffs were the prevailing party against his claim for the lien. And the court records, they're all cumulative proof sources and nothing requires any of the attorney's testimony. The motion is also entirely conclusory. It recites the counsel or witnesses with regards to the representation of Cordova, end quote, and to quote, the pertinent matters set forth in this action, end quote. Paraphrasing the rule is not the particularized showing that the rule demands. Mr. Martin and Mr. Olson, as his attorney, identify not one specific fact obtainable from only counsel. Every exception applies to this matter, that the chronology representation of the facts are uncontested. A2, that the fee-related testimony is expressly protected. That's the nature and value of legal services cited under the rule. A3, also under substantial hardship. We're 5.5 years in. We have 3 attorneys that have worked consistently on this case since its inception. And on the eve of a dispositive ruling, they make this motion. That's the definition of the hardship. And then Rule 3.7b forecloses blanket disqualification. Firm level disqualification requires a rule of professional conduct 1.7 or 1.9 conflict. None is even alleged here. Timing also just tells the story, Your Honor. In closing, the defendant has known who plaintiff's counsel are since well before this case was filed, all the way back to 2014. 2020 was when this specific malicious prosecution action was filed, and this motion only appears on the docket on May 14th of 2026, 16 days after we renew our motion for summary judgment. And I just want to quote Mr. Martin, the motion to disqualify. It said, quote, in an effort to come, counsel believes bring pressure to bear, Cordova's counsel sued in this civil action, Robert Martin. The motion is counter pressure admitted on its face. Quote, he also says, it is my desire to conduct a discovery of deposition of each of you. And this is Mr. Olson's letter to us. I'm moving this along quickly at this point. Mr. Rich noticed me to a hearing very quickly. That's this one. And Your Honor, I will just state as an intercalary, we got our signals crossed when we contacted the clerk's office, and we originally set this matter for before Your Honor by interchange, which we thought was available through the clerk's office. And then we were informed that Your Honor didn't have it. You didn't hear motions by interchange, and that original matter was incorrect. So we revised and sent in and filed a new notice placing this hearing for today's docket. So we didn't file anything without, this is the date for motions, and this is the date that we were intending to file it on. So the issue with the quote is basically in his cover letter that he's conceding that his entire package of these motions, the discovery and everything else, is just a reaction to our renewal for the motion for summary judgment. Finally, defendant's motion for sanctions, there's nothing to hear. No motion exists. Only a notice of a hearing related to motions for sanctions, end quote, was served on us on June 26th of this year. No sanctions motion has actually been filed with the clerk to our knowledge and served on the plaintiffs. And Mr. Martin's own filings prove it. The motion to continue, quote, reserves the right to move the court for appropriate sanctions. And the memorandum attached, quote, reserves all rights with respect to file a motion for sanctions under Rule 37. One does not reserve the right to file a motion that's already filed. So that hasn't happened. Rule 702 requires a motion stating grounds with particularity. Due process requires notice and an opportunity to respond before sanctions are considered. And we ask that the court decline to hear it and strike the notice. If the defendant ever files a real motion, we'll prepare a full briefing and respond. On the merits, it would fail anyway. Rule 3704, a non-appearance is excused where a Rule 2603 protective motion has been applied for, and it has in this case. To just touch on the plaintiff's motion for protective order, the 26.03, the good cause is overwhelming. 13 months of inaction after the leave was granted by Your Honor in March of last year. B, there was mail only service that compressed the response window to 14 days of actual receipt with no attempt to even confer with us on setting the deposition. It was set at counsel's office unilaterally on a date we were unavailable, and also while we had that pending dispositive motion set for this date. Rule 2603 states a court may make, quote, any order which justice requires. We cited a couple of cases, the Jackson and the NHC Nashville fire litigation case, citing the inherent authority of the court to prevent discovery abuse. And the relief we're requesting specifically is one that we quash the 5/14/26 notice of deposition on my client, that two, that her deposition be found by the court, as we've previously requested, to be unnecessary based on the admissions of Mr. Martin. And that number three, that Mr. Olson be directed on behalf of Mr. Martin to serve all future papers on us contemporaneously by email or fax. So there's not this thing where we receive motions and postmarked envelopes that are far after the date that's reflected in the date of service. And that, prejudices our ability to timely respond. So finally, with our renewed motion for summary judgment, we ask the court grant that. And this is the main matter that's before your honor. The standard of malicious prosecution is one, prior proceeding instituted without probable cause. That's here. Number two, with malice, and three, terminated in plaintiff's favor. And we've routinely cited the Christian versus Lapidus case in our briefing, the Parrish versus Marquis case. And the defendant ironically cites these exact same cases as for their response. So after adequate time for discovery, the focus is, quote, on the evidence the non-moving party comes forward with at the summary judgment stage, not on hypothetical evidence. The non-movement must do more than show, quote, some metaphysical doubt. And I'm citing the Lapidus case. Ground one, forfeited discovery, adequate time. The case was filed in December 2020, 5.5 years. The MSJ has been pending since September 19th of 2024. That's 21 months at this point. The court deferred the ruling on March 3rd, 2025, solely so the defendant could depose Ms. Cordova. For 13 months, they did nothing. And under Rye, adequate time has passed. The record is what it is. And, quote, he asked for it, he got it, he abandoned it. Ground two, the opposition on 2/24/25, that's back in last year, creates no genuine issue. The preamble of Section 21 misses the claim. Plaintiffs do not sue Mr. Martin for violating the rules of professional conduct. The plaintiffs are suing for the common law tort of malicious prosecution. Mr. Martin admitted violating rules of professional conduct 1.5C and 1.5E, which are evidence on probable cause. Section 21 of the rules of the rule itself states a violation, quote, may be relevant in determining whether there was also a breach of the applicable standard of conduct, end quote. His own authority, Mr. Martin's own authority, concedes that point. The affidavits of Mr. Martin and his assistant, Ms. Hockaday, don't create any factual issue. Even accepting that Ms. Cordova orally consented, as Mr. Martin claims, to his involvement, oral consent is not a legally enforceable contingency fee arrangement under Tennessee law and cannot supply probable cause for a lien. The Court of Appeals has already foreclosed this and found, quote, all the services Mr. Martin subsequently rendered inured to the benefit of the plaintiff. He never had a fee agreements with plaintiffs, only with Mr. Hodges. And I'm citing from the third page of the Court of Appeals findings. An affidavit restating a rejected legal conclusion is not evidence, Your Honor. Also, he misreads the White versus McBride case in the flagrant analysis governs whether an attorney forfeits any fee. It says nothing about whether pursuing a lien with no fee agreement was supported by probable cause. Hodges' estate recovering a fee does not give Martin probable cause for his own lien. Malice is his only evidence is, quote, in the motion that he argues is, quote, I never acted with malice. It's just a statement he continually makes. And bare conclusions don't defeat summary judgment. Malice is inferred from want of probable cause and improper motive. Ill will is not required. We cite the Cohen versus Cook case, 462 Southwest 2nd 502, and that's a Tennessee Court of Appeals case from 1969. We also cite the Howell versus United Rentals case, which is a 2023 Tennessee Appeals Court case found at Lexus 374. Course of conduct, the approximate 6-year lien pursuit by Mr. Martin, despite knowing that it was unethical and he had no written agreement to pursue it. And then subsequently after that, through Mr. Olson, he filed a second retaliatory suit against Ms. Cordova and all of her attorneys. He filed that case on November 4th, 2022, and then voluntarily dismissed it after a 13-month stall. Damages were being dragged through baseless litigation is the injury to Ms. Cordova. Ms. Cordova retained counsel, appeared, and defended the lien claim that he brought for more than 6 years. And we cite the Myant case that his quote, "between attorneys only" framing also contradicts his claim that he needs her deposition on damages. And then finally, he admits the favorable termination. It's admitted. The defendant's responses to undisputed facts 4, 5, and 6 in this summary judgment are all admitted that the lien claim terminated when Mr. Martin abandoned it after pursuing it since July of 2014, and that his later suit against plaintiffs and their counsel was voluntarily dismissed. So we would respectfully ask that the court award us the summary judgment, give us the judgment on the pleadings based on Mr. Martin's own admissions. I just finally want to say that throughout this, the questions that have been raised by Mr. Olson, why shouldn't Mr. Olson be able to take the deposition of our client now, since he just recently filed this notice in response to our renewal for this motion for summary judgment? And candidly, that's because it would reward 13 months of defiance of the spirit of this court's March 3rd, 2025 ruling. And because the deposition cannot change the outcome, as we've stated. The motion that we have before the court rests on Mr. Martin's own admissions in the Court of Appeals factual conclusions and findings. Nothing Ms. Cordova can say can unadmit Mr. Martin's Rule 1.5 violations. The second thing is the argument, isn't probable cause usually a jury question? And we specifically state that probable cause is measured objectively on the facts known to the defendant, where the material facts are undisputed. Here, no written fee agreement exists, which is admitted as a Rule 1.5C violation. The Court of Appeals found as a matter of law there was no fee agreement. Its existence is a question of law for the court, and clearly we know the answer. The preamble to Section 21, does it bar reliance on the ethics rules? It bars an independent cause of action based on a rule violation. We agree. However, we are pleading a common law tort of malicious prosecution. And Section 21 expressly allows violations to, quote, be relevant in determining whether there was also a breach of the applicable standard of conduct. Rule 21, or Section 21, specifically allows that. So we are making an allegation of a tort, not suing for a breach of an ethical violation. The favorable termination, as we stated, is admitted. He admits, and the Court of Appeals agrees. You withdrew this lien after 6 years of pursuing it, and the favorable termination is on the plaintiff. So there's nothing for the court or jury to decide on favorable termination. So specifically, what is it that we're asking for today? We wish the court to, one, deny the continuance that's been sought, deny clearly the disqualification under this pretext to, it's just, there's no basis for it of all of Ms. Cordova's attorneys. 3, decline to hear the unfiled sanctions motion because it's not even before the court. 4, grant our protective order against taking Ms. Cordova's deposition. 5, grant our summary judgment with the Rule 5201 findings And specifically, that is to bring and we will submit those Rule 5201 findings. The final thing I just want to point out for the court, which again, Mr. Olson and Mr. Martin continually try to say that there's not, that the damages, and that's Ms. Cordova's testimony. And I'll first state, if they're even right, which they're not, that would still allow the court to rule positively on our summary motion today, because we're just talking about liability. Did you violate the ethics rules with malice? That malice decision is you pursuing it for 6 years, knowing that it was unethical. So it's proven by Mr. Martin's own sworn admissions. Again, I'll point to his November 23rd, 2021 deposition, his admissions, the Court of Appeals findings, and the duration of his wrongful pursuit. July 2024, he admitted through January 14th of 2022. That's when he stopped and withdrew his claim. So the total is actually approximately 7.5 years. I apologize. And that's established entirely by the court's own records. We have filings, the orders, the hearing dates, the special master proceedings, and the appeal. The docket itself is self-authenticating and no witnesses are needed. And the contingency fee structure and who bears it. Plaintiff's counsel are compensated by contingency out of the family's recovery. That is established by the retainer agreement itself, and if needed, every dollar of fees, expenses, time, all of that is to be assessed by the jury. So the arithmetic on how we get to the damages, attorneys, fees, and litigation, that's all that was all incurred during the lien claim. That's proven by the record. The reduction of the family's net recovery, because compensation is contingent and paid from the plaintiff's award. The defense's burden is a computable subtraction from the fund belonging to the family. A math exercise from documents, not a memory exercise from a witness. And really what I want to just point out is effectively Mr. Olson argues, well, if Mr. Hodges had a lien claim, then Mr. Martin shouldn't be liable for anything, even if he committed an unethical act, because there was this lien claim. And I would say that exclusivity is not the test, the substantial factor is. And we cite the McClenahan versus Cooley case at 806 Southwest 2nd, 767, the Hale versus Ostro case at 166 Southwest 3rd, 713. And what it states is concurrent causes defendant's conduct need not be the sole cause. A concurrent cause of the same delay goes to an apportionment of the amount at trial. We would specifically say these were both all jointly filed motions, so it's 50-50. So the court can clearly apportion down Mr. Hodges, but that doesn't absolve Mr. Martin. And so it doesn't negate the damages of that element. And really easily understood, a man who wrongfully sues you is not absolved because someone else was suing you too. The defense costs are independent of any delay. Even if Hodges froze the fund regardless, no one had to answer Martin's lien except because Martin filed it. Every response, appearance, and special master proceeding directed at this claim over that 7.5 years is an expense attributable to him, severable by the simple subtraction of Hodges' involvement, the 50-50 involvement. And again, just her money is backwards, and it's why Martin loses. Contingency fees are paid out of the client's recovery. The fund was the family's, and the fee dispute determined how much of their money went to lawyers. That is precisely why Martin had to file his lien against the Cordovas. You don't file a lien on your own money. The Court of Appeals found he had no agreement with them, so every dollar he claimed was wrongfully claimed from the widow and her 2 minors. And no, quote, tied up anyway story explains the later 11-4-22 lawsuit that he filed against Miss Cordova personally, making her a party twice by choice. So the Hodges comparison cuts against him. Hodges had a written contract. The delay from litigating a colorable claim is the ordinary cost of a real dispute. Martin had no agreement and admitted ethical violations and piggybacked a baseless claim onto that litigation, extending and complicating it. The difference between Hodges and Martin is the difference between a lawsuit and a tort. This entire attack is a legal argument on the undisputed facts. The court records, the retainer, Mr. Martin's admissions. It requires nothing from Ms. Cordova, which further exposes that the deposition demand in this continuance is just a pretext. And because the element requires only some injury, a dispute over the amount does not defeat summary judgment on liability. The 6-person jury defendant demanded can apportion the damages 50-50 as we've identified. So, Your Honor, the damages here are arithmetic. They're not a narrative. The docket proves the duration. His admissions proves the malice, and the records prove the cost. There is nothing Ms. Cordova could say at a deposition that would add or subtract from any of those numbers. So respectfully, we would ask that the court grant our summary judgment as requested. And finally, I'll just say, if the court wishes to have it, I went through in detail. It took me many hours to do so, but I have a complete math of all of the motions and everything that were filed during the Martin dispute phase before he withdrew his claim. And so, for instance, there was 42 motions, substantive filings. There were only 12 after when Mr. Hodges maintained his lien claim. There were 4 court orders that were during his time. There were only 2 that followed. We had 5 hearings during that time with transcripts. We had one on 9/5/17, 6/19/18, September 4th, 18, and then the special master hearing on April 12th, 2019, and 20 separate filings, etc. So I have a dated chronology in all of the work, but that effectively is the evidence that we would present at a jury trial. And that is the only evidence the court really, the only evidence the court needs to consider. So with that, respectfully, we would ask that the summary judgment be granted, Your Honor. Thank you. And did you have any questions for me? Thank you.
Briefly, I don't really understand the way counsel is presenting this, and perhaps I don't need to. I'm just going to concentrate on the issues in this case. There has been a parallel case involving this case also that had to do with attorney's fees. It was resolved in the past, I'd say 3-4 months. Maybe it's a little longer than that. That case being resolved was important to this case because that demonstrates the attorney's fees division that was made with regards to the money. We, in that case, had several hearings, and it was before another judge, and we had a special master matter. Mr. Martin and Miss Hockaday testified. Mrs. Cordova did not testify. She didn't testify there. I have sought to depose her on 3 different occasions. 3, not once, but 3 different occasions, and she has never shown up, period. I have sought from counsel who is here today dates that we would go forward with this deposition, and she has never shown up. Ultimately, we noticed up a deposition because we were never able to get a deposition that would be sufficient to opposing counsel. At this point, I legitimately wonder if Ms. Cordova knows a lot about this. And I wonder if she
knows a lot about what?
About this civil action, because there has been a specific action on the part of counsel to not allow Ms. Cordova to be questioned. When we had the question about attorney's fees, she didn't show up. She didn't talk about that. She was not called by counsel. When we were scheduling a second special master hearing, at that point, finally, we got reasonable and we settled the claim regarding the attorney's fees for the amount that was set forth in the contract, which is what we saw years ago. This civil action against Martin is not established by anything that has gone on, and it is absolutely necessary that Ms. Cordova's deposition be taken, because these are just some of the simple questions we have. Did you agree to Mr. Martin being involved? Because she came to his office at least a dozen times and met with him. Did you agree with Mr. Martin's office being involved because Miss Emma Hockaday was there? Miss Emma Hockaday is a Spanish-speaking individual. She testified, provided affidavits that she came and participated. Did you agree that in fact he could participate and not take additional fees, but have the same fee structure as was presented by Mr. Hodges? The answer to that was yes. That's before this court right now. The question that I have that I think is so important is, why won't they produce this woman for a deposition? Because if we had had her deposition, we would be here today to conclude this motion for summary judgment. I have absolutely no idea why months ago they didn't do it, why they didn't do it when we requested, and why I had to actually notice a deposition that they opposed, that they did not appear at.
So when it's presented that there's been 13 months and that the first effort you've made to try to depose Ms. Cordova was earlier in the month of June, is that accurate as far as you're concerned?
No. I tried to get them to come to Clarksville. Miss Cordova, we sought her out and we found her. She lives in Montgomery County. This case, as Your Honor knows, is a Montgomery County case. It was transferred from Montgomery County to Cheatham County. She lives there. I called and said, hey, look, actually, I don't really talk to counsel. We communicate back and forth. I said, we really want to go ahead and I've got this date and I've got this date. Let's come up and do this deposition. No, we're not going to do it. Has to be done specifically on terms that we say at our office on this day. I said, look, let's just get this thing done and let's get it over with. No. We then concentrated on the money issues. And I'll tell you, Your Honor, why I did that. Because if the money issues, in my mind, are resolved based upon the terms of the contract that Hodges actually had, and Martin just agreed that, in fact, yes, we're going to work this together for the same fees, that contract becomes very important. Literally within the past, I've got a check actually here I've got to return it to the clerk because it was issued in a way that's not appropriate. But that actually resolved that case and resolves issues that are presented in this case. So I'm just going to concentrate right now on what we've got to do to answer this summary judgment motion. There has to be malice. There has to be some intent to harm. There has to be all these different things that are required under the representations that are required and the factors that are required for malicious prosecution. Those aren't present, but for me to demonstrate that, I have to have the thought process of this woman. I have sought that now for a long time. I have sought that for a long time. And all I'm looking for is the discovery deposition of this woman, and then we're prepared to argue the summary judgment motion. That's where I'm at on this. And respectfully, it was very important in my mind, and I'm gonna limit it just to the motion to continue right now, because if we can do that, then the rest of this becomes less important at this point. But we needed to complete, in my estimation, the money issues because it demonstrated what was taken from this lady. And what was taken from this lady was exactly what the contract provided. And ultimately, we finally reached an agreement. Counsel sent me an offer that I accepted. After the second time, the Court of Appeals sent it back down to be heard. So that's kind of where we are. I think we're entitled to our discovery. We've sought that discovery several times. And counsel, I really don't care if counsel stays in this at this point, but I do care about this. They need to answer the discovery about what attorney's fees have been charged. Have you an agreement with this lady to do this case for a specific fee? What are the damages that this lady has incurred? All of those things are important because, again, I don't think they've charged anything for the purpose of recovering money that is owed to them. I don't think this lady has incurred damage one. And that's really kind of where it comes down. So in terms of that, what we would like to do is get our discovery deposition. If Your Honor wants to reset this thing in November, as long as they'll cooperate and provide a discovery deposition on a date certain, we'll go forward. But I'd reserve the right to argue further, but I think that's what's probably best to talk about today.
Your Honor, I'm compelled to respond. Correct the record. First off, all of these claims about how he's tried to take Ms. Cordova, where is it before the court? All these things should be before the court in the record, and I would submit that they're not. What he's trying to do is confuse the court. He's talking about the Cordova versus Nashville Ready Mix case. That's a case that occurred before Judge Wallace. It was settled on an offer of judgment, has separate facts, and was only settled with Mr. Hodges and his estate. Those are separate facts in a separate case. It's not before Your Honor. This is a case of malicious prosecution by the Cordova family against Mr. Martin. Has nothing to do. So his statement that he's been trying to take Ms. Cordova's deposition for all this time and relating it to this other case that's not before Your Honor is just, it's wrong, and it's not before the court. And no evidence, no affidavit has been filed. If counsel wanted to file an affidavit saying, Your Honor, on this date I did this and I did this and I did this, he would be able to do it. He didn't do it because it doesn't exist. 13 months, nothing was done on this case, and that is a correct statement. The fact that he keeps going back to saying, what did Ms. Cordova agree to orally and that sort of thing? Again, that's our summary judgment motion right before Your Honor. It doesn't matter. It's unethical. If you're an attorney in the state of Tennessee, you cannot agree orally with a client to charge a contingency fee. The rules require that it be in writing, that it be signed by the client. He admitted to those infractions. So that just doesn't have anything to do with this case. It doesn't matter. The question of what did you talk to Ms. Hockaday about? Did you agree to this orally? Again, it fails as a matter of law, obviously. The thought process of this woman, he talks about damages. Okay, we'll talk about damages, but that is damages. We can get summary judgment right now on liability, malice, and the issue of the positive or the result in favor of the plaintiff. Those two things are established, as we state, by the record. So if he wants to ask Ms. Cordova about damages, let him do so afterwards when we have summary judgment, knowing that liability is established. This is just questions on damages. And I really think he kind of made a tell there, because all of his questions that he generates for the court, again, only deal with damages. And damages is a separate element. And we think that there's enough here, obviously, for the for the jury to rule based on the record. But if we're limiting this to damages, the court can go ahead with full eyes wide open, granting us our motion for summary judgment on liability. And then, sure, okay, we'll have a deposition of Ms. Cordova on damages. We're not preventing Ms. Cordova from testifying. What we're preventing is the continued abuse of her. Mr. Martin, through Mr. Olson, went ahead, as I noted in the record, and filed another case in November against Ms. Cordova. Personally, after this malicious prosecution case is pending, he actually goes ahead and drafts another complaint and sues her again. After that goes forward, he suddenly goes, oh, wow, I made a mistake, and withdraws it again. And it's a part of what's in front of the court again today. All of that goes to the damages and the question of damages. So respectfully, all of the things that he's bringing up have nothing to do with the matter before us. And he's just trying to confuse the matter by saying, I've done all this work to try to get her deposition, and it's just not reflective of the record. And respectfully, Your Honor, if it were, it would be before you. So again, the thought process of this woman, as Mr. Olson just stated here, and I wrote it down, the thought process of this woman as it applies to oral agreements and whatnot has nothing legally out there. There can be no muddying of the waters legally here, because we know that it is an ethical violation for an attorney to charge a contingency fee without a contract. And where did Mr. Martin go wrong in this case? Knowing that and admitting to that, he decided to still go ahead and sue his former client and pursue that litigation for 7.5 years. So liability is just not in dispute in this case. And we would respectfully ask that if a deposition is allowed on damages after your honor allows the motion for summary judgment to be granted, that it be limited to just that, damages, and not any kind of inquiry where we know Mr. Olson wants to go. What did you talk to your attorneys about? How often do you talk to your attorneys and things like that? This whole exercise is another way to try to abuse and maliciously prosecute and against Ms. Cordova. So respectfully, we think that the record is very sound before your honor, and that this 13-month period should not be rewarded by your honor just giving him additional time, because in response to us settling other unaffiliated litigation, that was Mr. Hodges' case that Mr. Martin was no longer a part of. Settling that had no bearing at all on this case. And so for 13 months, this case has sat idle.
If I can, I contacted my assistant because I didn't attach the emails, but not only did we have attempts to try and take the lady's deposition in Clarksville, when they wouldn't agree to do that where she lived, we asked if they would appear at the Cheatham County Courthouse, and we secured a room here at the courthouse to conduct a discovery deposition. And counsel would not do that either. So we could not come up with and my secretary just sent me 3 separate emails, which I'm happy to file, but we could not come up with a time or a date where this lady would appear. Respectfully, we attempted to conduct the discovery depositions. We suggested the discovery deposition be conducted here where the court was located. We suggested it be conducted at my office. We suggested that we do anything. And respectfully, this idea that in some fashion she's being abused, all she was being done was to ask to pay the attorney's fees, which she agreed to. Now, Martin didn't get it signed, but he had a signed agreement that was there from Hodges. And that's what the court ultimately gave the results that came about. Court of Appeals went up twice. Court of Appeals said, yeah, you've got a contract here, but we think you got the wrong number that should be used as one of the factors. Okay, come back. And when the Court of Appeals made that determination, then all of a sudden counsel wanted to settle the case, and we did. But what we need to have this woman's discovery deposition. I've requested it on 3 occasions. I've requested it at least on 3 occasions. And I don't understand and have not still understood why it is that we have not been given that. And respectfully, I haven't noticed people to a deposition that I can remember. I just don't do that as a practice. And we only did it in this case because, once again, we could not reach a point where we were going to go forward and conduct the discovery deposition by agreement. And respectfully, we're entitled to that. So my recommendation is before I argue about summary judgment, let's do the discovery deposition. Let's set everything in November, and then we can go forward.
We can go back and forth about this all day. Both of you have your positions, and this is the case I've heard before. And I granted some additional time to the defendant to depose or do the discovery. Obviously, both of you have versions about why there was no discovery deposition of Ms. Cordova. Unfortunately, she is the plaintiff in the case, and therefore I think the defendant would be entitled to take her deposition. But I agree that a 13-month delay is, in my opinion, a inordinate amount of time for this to have been pending since I last made that ruling. I want to know right now how quickly you two can schedule a deposition here at the Cheatham County Courthouse for Ms. Cordova to be taken by Mr. Olson, because I'm looking at the 22nd day of July to reset the motion for summary judgment, give them an opportunity to depose her, and then we come back on that day
and do it Monday.
Your Honor, I would need time to confer with my client. I also have I have a trial next week, and so I would need some time. again, I think if the court is so moved to allow her deposition, then we can maybe do it, say like the court gives us a certain period of time to get it done. And then we could potentially, if by agreement, if it is appropriate, maybe we can set it before Your Honor by interchange of one of the other.
That's what I was going to suggest as an alternative, is that I'm very sympathetic to your situation, and I understand your frustration for the length of time. I know that Mr. Olson's had some health issues, and other cases, I'm aware of the fact that he's had those issues that have affected his ability to be as timely as perhaps he should have been in some cases. Having that knowledge, I'm inclined to grant him one opportunity to discover that. So I'm going to order that within the next 10 days, you arrive at a date for a deposition. The deposition will be taken here. I'm saying if within 10 days, you set a date for a deposition. Once that deposition is taken, then you may come back, you may contact me, and we'll find a day to shoehorn you in somewhere else if necessary on the motion for summary judgment. You understand, Mr. Olson, what I'm saying is I'm giving him 10 days so that he can consult with his client, 10 days to find the date to set a deposition. If it's 30 days down the road, 60 days down the road, or whatever. Obviously, I would like to get it done as quickly as possible. I don't want to delay. And I want a date set certain where both of you can be there, and you'll have the interpreter and everything that's necessary. We can secure a room here at the new portion of the courthouse. If you just contact Miss Holly, she can do it here. That way you've solved the problem of whether it's going to be at your office or in Clarksville or wherever. We'll do it here at the courthouse where this matter is filed. Once that is taken, the deposition is taken. Upon taking the deposition, then I'm simply reserving your renewed motion for summary judgment to allow that. And then I will set a date for the hearing of that motion, and we'll go forward from there.
If I can, Your Honor, I'll provide dates. I will cancel anything I have except for trials. I can't do that without the court approval, but I will provide him with dates for the next 30 days today.
Well, both of you seem so reasonable when you're standing right here. What I perceive, and having done this for as long as I have, is I perceive that when you walk outside of those doors, you're not necessarily going to be as agreeable with each other. So I'm just simply telling you the way we're going to do it. You got 10 days to set that date. Both of you find a date to do this deposition within the near future. I'm not setting it. It has to be 30 days, 60 days, whatever. But I want a deposition scheduled with all of the necessary situation scheduled here in the courthouse, and then I will allow you to set it in front of me wherever I can set a date for it.
Very good. Thank you.
Two things, Your Honor. I'll submit the order identifying the 10 days and what the court has found. But I would also ask that the court just restate that the limitations on her deposition that were found back in March of last year.
Whatever the limitations were on the deposition that I set in the original order granting the deposition continue for this deposition. So they need to be restated.
Yeah, and I think, Your Honor, what I wrote down here is that Martin's state of mind and conduct are the issues that can be talked about. No privileged communications and no communications with attorneys. So that was what Your Honor made the scope of.
Whatever I said initially.
Okay. Thank you, Your Honor.
Thank you.
That's all I had.
All right. Well, that concludes my circuit court docket. So before we begin the Chancery docket, I'm going to take a short recess. So. All right, call the next case.
Your Honor, this is a petition for amendment of title. Miss Callis was the wife of Mr. Callis. When he died, he did not have a will. He had the property in his name solely. He had one other child. We've spoken to that adult child, but she would never respond otherwise or sign any documents. So we just need the property transferred into both of their names to finish the estate.
Then let's go ahead and put Ms. Callis under oath so that you can put that in the record.
Yes. Please state your full name for the court.
Deborah Shane Callis.
At the time of the death of Ronald L. Callis, were you married to him?
Yes.
Okay, and after his death, did you learn that the real property was in his name solely?
Yes.
Okay, and he has an adult child that was not your child, is that correct?
Correct.
He had no other biological children, is that correct?
Correct.
And you never located a will, is that correct?
Correct.
And you're asking the court just to transfer title of this real property into the name of you and your stepchild.
Correct.
Okay.
All right, I will grant your petition for monument of title.
Thank you, Your Honor.
Good morning, Your Honor.
Good morning.
John Kitch of the Tennessee Bar. I'm here today on a motion to substitute trustee. You may remember this case. What happened was there was a will and then a codicil written all over the will, and you're admitted to probate. The trustee that we're asking to appoint is the current personal representative who you appointed earlier. I have filed declaration by him indicating that the bank doesn't want to serve as trustee because there's not enough money.
It's like $50,000, isn't it?
Well, there was originally about 500,000, but after we paid some bills, it's reduced somewhat. I have filed declarations of all of the residual benefits.
Interesting that that's not enough money for the bank to feel like they can do it.
Well, I'd serve as trustee for it, but they didn't ask me. And this is Mr. Nathan Palazzi, who you may or may not remember as a Kingston Springs police officer. And the people who are the trust beneficiaries have all requested him, and we are just asking that he.
I reviewed your file, Mr. Kitch, before today, and I thought your motion to substitute Mr. Palazzi was the appropriate way to handle it. Since everybody's in agreement, I would be glad to approve it.
I have a proposed order if Your Honor is interested.
Thank you.
Pardon? I will do that.
We're in a new courtroom, but you want to carry over some of the eccentricities of the old courtroom. If you've ever been in the old courtroom and you walk through one of those swinging gates, the bailiffs do not like it when you just walk through and let it just swing back and forth like a bar room. So we've made sure that this one is going to have to be the same kind of thing. We've got a new gate here that will whack if you don't hold it when you walk through.
I apologize.
You don't have to apologize. This is a brand new courtroom and a brand new day. I'm just simply telling the lawyers that they need to watch, because also it could pinch a finger pretty good too, I think. So. All right. Thank you, Mr. Kitch.
And will I be able to get a copy of the order today?
Case number 20003, Emily Catherine Stacy.
Good morning, Your Honor.
Good morning. If you'll raise your right hand, let's place you under oath.
Yes, ma'am.
You are Emily Catherine Stacy, is that correct?
Correct.
You have filed a petition to change your name, and I was going to ask you, how do you pronounce the last name?
Bonchak.
Okay. Ms. Bonchak, you were asking to change your name back to your maiden name after a divorce. Are you asking to change your name to avoid any just debts or creditors that you might have?
No, Your
You're
Honor.
asking to change your name to avoid criminal prosecution.
No, Your Honor.
Then I will grant your request to change your name. Do you have an
Thank you.
order? Have you prepared an order, which would be a separate document that grants your request for a name change?
Yes, ma'am. Yes, sir. I'm sorry.
That's all right. At the top, it should say order.
Final decree name change. I might have done two.
This is the petition. I'm going to hand that back to you. So there should be a different document.
Sorry. I'm nervous.
All right. I've granted your order, signed your order, and granted your name change. You can get a
Thank
copy
you.
a little later in the day. Okay.
Okay. Thank
All right,
you.
thank you.
Your Honor, we have two motions. We were here previously on our motion to compel the discovery responses. That was continued as his attorney withdrew from the case. We still have not received those responses. We also have asked the court to waive mediation and just set this for final hearing. His attorney withdrew because he was not participating, and I don't anticipate that he will participate at this point.
Well, is there any point in me ordering the motion to granting your motion to compel?
No, Your Honor.
All right, we'll just set it for a hearing. When do you want to set it?
As soon as possible, Your Honor. My client's ready to have this done. The parties have nothing. They just need to be divorced.
How about July 27th?
That would be great, Your Honor.
I can give you July 13th for that matter, but you got to give him notice. So I'd
Yeah.
say July 27th.
That'd be great. Thank you, Your Honor.
All right.
Morning, Your Honor.
Good morning.
Andrew Triplett with the Sumner County Bar. I'm counsel of record for a creditor on a testate estate, the estate of Gerald Gish. Miss Peggy next to me is counsel for the estate with Doris Salinas as well. We're here for two matters that coincide together. This is my client's petition to vest the decedent's real property into this estate pursuant to TCA 30-2-403, and also a creditor claim that was filed on this estate by my client, Marcus Hadlock. He was the decedent's business partner for several entities. We filed that creditor claim on the estate on March 19th. The estate filed an exception, and we reset the hearing on the exception to that claim for today. And I have two witnesses from my client that are here to testify in support of the creditor claim. Because that, I would request this matter be moved to the heel of the docket.
All right. Anything to add to that, Ms. Smith?
Not if we're moving it to the end of the docket, Your Honor.
All right.
We can.
We'll move it to the end of the docket, but that's only about two other cases away, I think. So
Yes, Your Honor.
we'll give you a few minutes.
Thank you.
Okay, thank you.
Your Honor, if I may, I apologize. I'm attorney Henry Garth Click. You'd handled the Jones estate just a few minutes earlier, and I was racing to get here as fast as I could from Clarksville, and I apologize. I'm late, Your Honor.
Sorry.
And I
Did they
understand.
tell you what we did?
Yes, Your Honor. They filled me in on all the details. I just still wanted to come in and let Your Honor know
It's fine.
I was here.
I
just
understand
ran
how
late.
it is. Coming from Clarksville to Cheatham County is not always the safest and most direct route anyway.
Well, I've found it's never a good idea to try and go to Clarksville first, because I think they have their courthouse on wheels and are constantly moving it farther and farther away.
Would you spread that word to the other Clarksville attorneys, please? And
I'll do my
let them
best. I'll
know
tell them all to their face, Your
they
Honor.
should not go to Clarksville court first. They should come here first. And then we'll take care of them, and then they can go late to Clarksville. So,
Those they've got plenty of judges. Somebody will be there for them.
all right.
And I just wanted to apologize, Your Honor.
They
It's
do
been-
have plenty of judges, by the way. So
I know, Your Honor. I practiced
I think
tons
they
in
have
Springfield.
8 judges for 2 counties. So we have 4 judges for 5 counties. So.
Well, I do primarily a lot in Springfield, Your Honor.
But let me just say this for the record, in case any of my colleagues are watching this on YouTube. I really like all of those 8 judges that they have. I really appreciate being with them. I think they do a wonderful job.
But I just wanted to come in and make my appearance before Your Honor. It's been about 10 years since I've been before Your Honor, and I just didn't want you to think I just completely
That's all
failed on it.
Glad you're here safely.
Thank you, Your Honor.
All right, now call the next case.
Case number 18943, Nathan Reynolds versus Catherine Reynolds.
Just for the record, I also came from Clarksville, but I did court in the car in the parking lot.
That's what's going
under the bus.
I made it work. Your Honor, this is an ex parte filed by father. Father is not here. Many of the allegations in this are grossly incorrect and false. This is also the second time that father has filed something and not shown up. It's costing my client thousands of dollars at this point. I would respectfully request that her attorney's fees are granted for today. I can address the motion if you would like to, but
Well, we have received an email and apparently a call from Mr. Carver who states that his email states, due to an apparent, and this was sent to the clerk, due to an apparent oversight on my part, I was not aware the court had set a hearing date on my ex parte motion on this matter. I was simply informed by staff it had been denied. I am out of state and unable to be present. If the court wants to strike the motion or reset it, that is acceptable to me. I will merely ask that no cost or fees be assessed my client, as it was my oversight that caused the mix-up. So if there are costs to be assess them to me. I believe at least one of the other attorneys will be there if we can get this matter set for a trial date. That would be phenomenal. The case has been pending a long time on the mother's petition and to the detriment of the father. Thank you and sorry for any inconvenience. Now, he also called, I guess, and said he had was unaware that it was set for today. So I am not inclined to rule on the matter without Mr. Carver being present, but I will reset it. And if you want to submit your affidavit for your client's attorney's fees, then I will consider that a separate matter. The question is, did Mr. Carver give you any indication that when he would be back and able to do this? When do you want to set? You want to set this for a final hearing, or what are you going to do?
I would like the parties to attend mediation. However, the issue with that is my client can't afford it. Now, I know the National Conflict Resolution does it for free. Mr. Carver says he does not enjoy using them, but I think that could be something beneficial. Or father can pay her mediation fee. She just simply can't afford it.
All right, the order will be that you will attend mediation before setting it for a final hearing, and that you will either attend that free service through Nashville Metro, or Mr. Carver's client will pay for the entire cost of mediation. I'm giving him the out to do it for free, or if he doesn't want to use them, then he can pay for everything.
Absolutely. Would you like to reset this motion while we're here? or leave that to Mr. Carver?
You've asked the wrong questions. It's like when I used to practice law and I'd go to my office after a long day of court and I'd sit down and my secretary would come to the door and say, "Do you want to talk to so-and-so and so-and-so?" I said, "You've asked the wrong question. Do I want to talk to so-and-so? No. But will I talk to them? Yes." So your question is, do I want to set this for a hearing? No. But
I'll
will I
rephrase.
set it for a hearing if you want it to be? Whatever you want to do. I don't care if you're going to, it's his motion. So therefore, it seems to me he should be the one to try to reset it.
I agree. And if he does reset it, then I can just set a motion for fees at that time as well.
That's fine.
Thank you, Judge.
All right. Thank you. Okay, call the next case.
New courtroom. Do we have a preference on plaintiff and defendant on this one? Okay. Your Honor, it appears that a witness has came up with the gentleman. And I don't believe-
Is the rule being requested?
Yes, Your Honor.
The rule is requested, therefore, anyone who is not a witness or who is not a party to this proceeding must go outside of the courtroom and remain outside until you're called to testify. You will need to step out the back door.
Yes, yes, our witnesses have to come up.
You represent Terry Pewitt and Susan Valentine, is that
I
correct?
do, Your Honor.
All right. And you have filed a petition for letters testamentary and to appoint an executor.
We have, Your Honor.
And has that actually been heard already?
It has not. It's been continued twice. Today's the third appearance on that. At the last appearance, first, Ms. No was going to represent this gentleman, and then he was unable to hire her. So at the first court date, it was continued for him to obtain counsel.
So we're here on your petition to
We are.
appoint an exec or co-executrixes,
Yes,
and then also to admit a holographic will.
yes, Your Honor.
What is your name, sir?
William Hyman. I'm Fannie Rose's great grandson.
Just go to that microphone if you will.
My name is William Hyman. Fannie Rose's great grandson. I live in her house. I have the last like 10
Right.
years.
And that's at 1313 Randy Road, Ashland City.
Yes, sir.
That's where you live.
Yes, sir.
And that belonged to the decedent.
Yes, sir.
All right. And why are you here today? What are you seeking?
Miss No submitted the will that my grandmother had drawn up in 2020 by Mr. Lockhart over here, and I'm here trying to push that one as the last will and testament, rather than these holographic wills. When we were here the last time, like the first time we were here, they submitted the holographic will that didn't have my grandmother's signature at the bottom of it. And then they had the same words typed out on a piece of paper that was followed by a signature and a notary stamp. Then when we returned this past time, they admittedly that was no longer valid. They said that they admitted that there was no signature at the bottom of the handwritten page, so they asked to have it removed and not taken into any account. They then submitted a 2023 will that was holographic that they attest is written entirely in my great grandmother's handwriting, which I'm not arguing. However, to the signature at the bottom of the page is not written in the same ink pen. It's a whole different shade. It's stipulated, and I ran it through some AI signature comparison.
You can't testify about AI signature comparisons. That's inadmissible in this court.
Okay, but as you can see, just by looking at it, it doesn't
You
match
think
up.
it's not her signature?
Yes, sir.
All right. So is that the will you're seeking to introduce?
It is this will we're seeking to introduce. We have witnesses in the
Oh,
hall. We
let me-
also have a video too.
They also said they had a video the first time we came to court of her signing the 2025 one as well, the one that they said was not admissible. So
Well, let me explain to you. We're going to have a hearing, and I'm going to let them put on their proof since they were the original moving party. And there is a law that governs the introduction of a holographic will. A person, any person, I could walk out of here today and I could draft me a new will
Right.
as long as I sign it all in my handwriting and I sign it.
Right.
Then if I were to drop dead on the way home, then it could be introduced as my last will and testament, provided that they introduce at least 2 witnesses who will testify that they recognize my handwriting and that they know that is in fact my handwriting. That's all that's required for a holographic will. So we're going to have that hearing, and I'll let Ms. Crabtree put on her proof.
Okay.
You just have a seat right there. If you're a party to this action in the sense that you're a beneficiary or an heir, then I will give you an opportunity to ask questions and then later put on your proof if you wish to.
I was originally supposed to be the sole.
I'm sorry?
I was originally supposed to be the sole beneficiary, and with each holographic will that has been presented,
Come back to the microphone. We're making a record, so.
I was originally the sole beneficiary listed on my grandmother's estate, and I have Margaret Brady would attest that she had actually spoken to my grandmother later on, about 2 years later, about redoing her will, but still labeling me as sole beneficiary. But yet each holographic will that has been presented, both the one that was originally presented and then the one that just happened to show up after the first court date, just benefits the Miss Pewitt over here just more and more. And she was also the caretaker of my great grandmother when she went into hospice.
All right. Well, my suggestion would be, number one, that you've been given an opportunity to hire an attorney. And if you are going to raise the issue of the beneficiary of this will having exerted undue influence on your grandmother because she was a caretaker for her, that is a basis you can do, but you would have to file a will contest.
Right.
Though, in that
I believe that's what.
Just be quiet while I'm talking.
I'm sorry.
That would likely require you to have a lawyer to know how to do that. And that would be done after I have this hearing. You can still preserve your right to file a will contest if that's what you wish to do.
Okay.
All right. Have a seat. Ms. Crabtree, you may call your first witness.
Your Honor, I call Terry Pruitt.
We're going to ask this witness stand is around here, so you're going to have to come around and we'll ask you if you will raise your right hand. Let me place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth. So help you God. All right. This is actually the witness stand.
Oh, that's going to be really bad.
It's a little bit awkward, but we now have a camera there on the witness stand, so you can see her on the screen as well. All right, you may proceed.
Please state your full name for the court.
Terry Pewitt.
Okay. And how were you related to Fannie Rose?
I'm her granddaughter.
Okay. And you were present and spoke to Miss Rose when she decided to change her will. Is that correct?
Yes.
Okay. And you have submitted a petition to this court with a will dated December 13th, 2023.
Yes.
Were you present when she was writing this will?
Yes.
Okay. And there were actually recordings of her while she was writing this will. Is that correct?
I believe so.
Okay. But you didn't record it.
No, I did not record
Okay.
it.
Were you with her when she signed this will?
Yes, I took her to my bank, Pinnacle Bank, and had Betty Jo was going to notarize it. My grandmother signed the paper, and then when Betty Jo got it and read it, she stated that she could not notarize it due to it being a will.
So Miss Rose thought she had to have it her signature notarized.
Yes.
Did she sign it there in the bank that day?
Yes.
Okay. And do you know of any other will executed or after subsequent to December 13th, 2023 that Miss Rose attempted to make?
The one in 2025 that was found invalid.
Okay. And but this is the last will you're aware of that Miss Rose signed, correct?
Yes.
And you're asking the court to enter it as the will of Fannie Rose. Is that correct?
Yes.
And you understand you would be a co-executor of this will.
Yes.
You understand you have legal obligations to gather her assets and distribute them specifically as Miss Rose requested. Is that correct?
Yes.
And are you agreeable with doing so?
Yes.
Have you ever been convicted of a felony?
No.
Did Miss Rose own any kind of business entity when she died?
No.
Okay. No further questions of this witness, Your Honor.
Mr. Hyman, you are representing yourself. I will give you an opportunity to ask a question if you want to. Go to the podium, but it has to be in question form. It cannot be a statement.
Yes, sir.
All right.
Okay, so you said that the will in 2025 was found invalid, correct?
Yes.
Okay, if the will that was written in 2025 was invalid, then why was it that the last time, the first time we came here, y'all swore that it was notarized and signed in front of y'all with video that showed her signing the paperwork?
She had notarized it, got that will notarized, but we did not know that you also had to have two witnesses sign it at the same time as notarized. So it did not have the two witness signatures, which made it invalid.
But where did the video go?
My daughter has it.
Okay, so if there's a video of her signing this will in 2025, then that would show 100% that that was a valid will, correct?
Yes, if her signature is
That's a
on
legal conclusion that you're asking her a question that calls for a legal conclusion,
Okay.
and that's
Sorry.
not admissible.
Sorry. So, okay, so did the will in 2025 state that it was supposed to render all previous wills null and void?
Yes, she stated in the first sentence that
So,
she wanted to change her will and testament and did it of free mind.
so ultimately, the one that was presented from 2025 would have canceled out the one that y'all are presenting today.
Again,
Yes,
that's
if
a
it
legal
was valid.
conclusion.
Sorry, I'm
You
sorry.
can't make a statement of what you want it to say,
I'm sorry.
and you're making a statement of a legal conclusion, which is up to me to make that decision.
I'm sorry. How close exactly were you with Miss Rose before? Before her death?
I took care of her for 6 months. She lived with me. Me and my daughter took care of her on hospice. We took her to doctor's appointments. When she was in the hospital, we were there 24/7 with her while you never visited.
Now, we're not gonna. Sorry, guys. Stay home. Would I have been allowed over at the house that she was at?
You were allowed at the hospital.
If I had attempted to visit her, would I have been allowed at the house that she was residing at, or even allowed to speak to her on the phone herself instead of speaking through somebody else?
You were allowed to contact her through phone. You were allowed to see her at the hospital the numerous times she was at the hospital. You were not allowed at the residence due to your felony record.
So when my fiance asked if she could come over to see her and she was told no, was that because of my felony record as well? Because she has a squeaky clean record.
A lot of the decisions were left up to Granny. We asked her what she wanted and she made her decisions.
Okay, so you said she lived with you for 6 months. So when exactly did she move in there?
She started staying with me off and on back in July. She moved in with me permanently in November, and she passed away January 28th. And we were there when she took her last breath.
Okay, man. What time was that she took her last breath on January 28th?
6:28.
So do you know why my son called me at 5:38 that night asking questions about reverse mortgage and whatnot? And then
I can't speak for what he did.
Any other questions?
no, sir.
All right, thank you. Any redirect?
No, Your Honor.
Thank you, ma'am. You may step down and have a seat. Call your next witness.
I call Miss Valentine, Your Honor.
Valentine.
You need to go right over there.
Ms. Valentine, we're going to ask you to come right around here and have a seat in this chair.
Right here.
Right around here.
I'm going slow.
That's all right. Now I'm going to ask you to raise your right hand, and I'm going to swear you in since my clerk's on the other side. I don't know if you can hear. Go ahead. All right. Miss Rhonda has a really nice, soft voice. She has a nice, soft voice, but sometimes you can't hear her very well. So I want to make sure you
Well,
can hear.
I'm hard headed, so that makes we've got a mutual.
All right. Then have a seat, and if you will kind of speak towards that microphone. So,
At first, I thought you were talking about this Rhonda, and I thought I've never been accused of having a soft voice.
there are a couple of other attorneys I can lump in that same category. So.
Ms. Valentine, would you please state your full name for the court?
Susan Cooper Valentine.
And how were you related to Miss Rose?
She and I worked together and have been friends for over 50 years. And my mother even considered her a second daughter.
Okay. And you petitioned the court with Miss Pewitt asking to be appointed as the executor. Is that correct?
That was at her wishes, yes.
And that was in the will that we initially presented to the court.
Yes.
Okay. And since then, we've located a will dated December 13th, 2023. Is that correct?
Correct.
I'm going to pass you a copy of that document. How long did you know Miss Rose?
For at least 50 years.
Okay. Would you look over, did you, over that 50 years, get to see her handwriting and her signature?
Yes, I did.
Could you look over that document that I passed to you? Does that appear to be her handwriting?
I'm looking at where she wrote my name. Yes, that part I know for a fact. And this
does
is
the
her
second
signature.
page appear to be her signature?
Yes.
Okay. Do you have any reason to believe this is not her will that she had wrote out?
No, I do not.
Okay. I'd like to, we have already submitted a copy of the will to the court, Your Honor.
All right.
Okay, ma'am. Did Miss Rose come to your
It appears
home?
that I have the original in the court.
You do, Your Honor. Okay. At any time, did Miss Rose come to your home with a will prior to 2023?
Any will she brought, she came back at a later date. She and I went out once a week, every week. I came to Pleasant View and picked her up, and we had our usual day out. We wound up back at my house in White House, and there was one other will, and she wanted it, and I gave it to her, and she went into my dining area where my shredder is, and she shredded that will.
And was that the will that she'd had prepared by an attorney?
Yes.
Okay. Why did she shred it? Did she tell you why she was shredding it?
Yes, she did.
And what did she state?
She was very unhappy with her living circumstances, and quite frankly, she was afraid of Brad.
And that's her grandson, correct?
Yes.
Her great grandson that's here today.
Yes.
And you heard him testify. Did she ever state that she wanted him to inherit her items after that date?
No.
Okay. And did she tell you why she was afraid of him?
Well, she didn't tell me, but there was a lady that supposedly committed suicide there. And after that date, she was afraid of what he might do. And she told me that one time he had made the statement that he had burned it down before he let anybody take anything there. And she said, well, please don't let me burn too.
And do you believe that the will we have submitted today to be the last will and testament of Miss Rose?
Yes, I do.
Okay. No further questions of this witness.
Hyman, again, you have the right to ask questions if you want to ask a question.
Mr. Valentine, do you mind asking how old you are this year?
I'm 81 years old, and I'm fully aware of my capabilities and my senses.
Okay. Is it possible that your vision might not be as good as it once was?
No. I get my eyes checked every year, and the doctor will change my prescription if it's necessary.
Okay. You said you went out with Miss Rose every week, and which y'all would go out shopping and out to eat. When was the last time that you actually went out on a date with her?
I can't tell you the exact date, but I can tell you it was prior to her going in the hospital, because after she came out, she told me about her heart problem.
Do you remember the car wreck she had that totaled her vehicle?
I'm sorry.
Do you remember that car accident that she had that totaled the vehicle that she was driving?
I certainly do.
Do you remember how many years ago that was?
I couldn't tell you. I mean, there's been so much going on, and we've been up here so many times.
Maybe possibly like 5 years ago, something about around that. Sound about right?
I can't say for sure, no. But I do know after that time is when, instead of her meeting me in Springfield, I started coming to Pleasant View to get her.
For that one time, as you stated, correct?
I'm sorry.
For that one time that you stated, correct? The one time that you said y'all ended up back at y'all's house, that was the one time you came back to Pleasant View to get her, correct?
After the wreck and after she went in the hospital that one time, and she was telling me about her condition.
So do you remember when I was driving her to Springfield to meet you prior to you driving out to Pleasant View to pick her up?
I remember you bringing her 2 or 3 times, yes.
Okay, so if somebody's afraid of somebody, do you think they're going to ride with them while they drop them off to go spend their girls' day out?
Well, when you're dependent on somebody, sometimes that overcomes your fear. And then when I told her I'd be happy to come and get her, and there were a few times that she called me and she said, I can't meet you because Brad can't bring me.
Could it have possibly been because Brad was working and paying bills at the house, or is it just that Brad wouldn't?
I don't know that Brad worked. Now, you're asking for my opinion, and I'm giving it. She and I talked frequently, and I know that she was living under pretty poor circumstances.
It's speculation, but thank you.
Well,
no more
some of
questions,
your
Your Honor. I'm
questions
sorry.
are speculation too.
He's
No,
objecting. He doesn't know the proper
Yeah.
form, but he's objecting to you making an assumption or speculation about why she would. The statements that you're making about what she said to you, and that normally is not admissible because it's a hearsay statement of a decedent.
Right.
So we're really just here about whether or not she recognizes this to be the last will and testament, and
Right.
is she aware of it being done?
Right.
So if you have questions about that, I'll allow it, but I'm not considering.
I have no more questions.
All right. Any redirect?
No, Your Honor.
Thank you. And now you may be 81, but you're just barely old enough to be president. Did you know that? All right.
Right now, I'm taking care of a disabled veteran.
Oh, good for you.
My son.
Well, I'll credit you for that. So be careful on your way out.
Oh, yeah. I'm not senile yet, Your Honor.
Oh, no.
Your Honor, I call Constance Richardson. She's in the hall.
What's her name?
Constance Richardson. Just a little fast. No, you're just a little fast.
I am, and I claim it.
Miss Richardson, you're going to go that direction.
Come right around here, please, ma'am. The second chair here. You will raise your right hand and face our clerk. Over here.
I do.
All right, thank you.
Ma'am, please state your full name for the court.
Constance Richardson.
And how were you related to Fannie Rose?
She is the grandmother of my son.
So you're not biologically related, is that correct?
Correct.
Okay, I'm going to pass you a document. Over the time that you knew Miss Rose, did you have a chance to see her handwriting?
Yes, I did.
And did you have a chance to see her signature?
Yes, I did.
Does that document appear to be in her handwriting?
Yes, it does.
And could you look at the second page and tell the court whether you believe that to be her signature?
It does appear to be her signature.
I'd like to submit that as an exhibit to her testimony. That's a copy of the will we submitted, Your Honor.
All right, we'll mark that as Exhibit 1 to this hearing.
And ma'am, at any time did Miss Rose tell you that she changed her will after the date of that document?
After the date of that document?
Well, that was in 23. You know she attempted to do changes.
So she gave a will that was done to my son, Skylar Heineman, and we delivered it to Susan.
Miss Valentine?
Valentine, yes. Miss Susan Valentine. We met her at Goodwill parking lot with it. She told me she gave it to him, as well as Skylar told me that she gave it to him before I got Skylar. And then whenever I had picked Skylar up, we had went and we met her at Goodwill in Madison, and we provided her with that will.
Okay. And that will wound up not being a valid will. Is that correct?
That is correct.
Okay. Do you know of any other valid wills that Miss Rose has executed since 2023?
No, I do not.
Do you understand that to be her wishes?
Yes, I do.
Okay. No further questions of this witness, Your Honor.
Mr. Hyman, do you have any questions for this witness? Sir.
So you say that Skylar was provided with a will by Ms. Rose, correct?
That's correct.
Okay, so would it be possible to get Skylar to come down to be a witness? Or did he possibly say that he wasn't contesting his grandmother's will and that he wanted nothing to do with it?
He has not been asked because I'm not aware if my 16-year-old son can testify. Because my 16-year-old son can testify that he was provided with a will by Miss Rose, asked specifically to deliver it to Susan and not to say anything to anyone. So it was not known it was a thing to where she could do it on her own accord. She wanted it to be a secret. She didn't want it to be known so nothing could happen to it.
Okay, so you say that you're well versed in her handwriting and her signature, correct?
That's correct.
Okay, so same here, same will. Yeah, yes, it's the same will that she has. It's a copy of the same one.
This is Exhibit 1, a copy of the same will.
Well, now, will you look at the handwriting at the top of the page and look at the smoothness of her handwriting, and then take a good look at that signature at the end of it and tell me if you see any issues there. Is that truly her handwriting?
I don't really think that there's an issue with any of the handwriting or there's anything questionable about the will. I think that it's suffice it to say that when somebody is writing a letter, that their handwriting is going to change throughout that letter, especially when you're elder, I feel like. So honestly, I think that, it looks consistent. There's nothing, and honestly, people sign their names differently than they do when they write it down in a letter as well. So.
But as you said, the handwriting might change throughout the letter, but
a signature is pretty still
would
intentional.
you not use the same ink pen to sign it though?
Maybe she ran out of ink. I don't know.
When was the last time that you were actually around Miss Rose? Like,
I was actually with her on Christmas.
I'm not talking about that.
And
I'm
I
talking.
actually visited her after before she had passed away. So I'm not sure what we're.
Well, when was the last time you were around her where you would have actually seen her handwriting and
Honestly, she
that
gave
it-
my
in
son
that
a
context?
card for his what was it third was his 3-year-old his third birthday when she came to his third birthday. Mason, yes, she gave him a card. I was trying to find it, but I did not find it.
Okay. Am I allowed to submit, like, show some more handwriting samples that compared to the handwriting that?
If you have handwriting samples that you want to submit,
Yeah, I mean, it's just, never mind. I'm just trying to think. Sorry, I'm not don't really know what I'm doing up here. So, I guess no further questions on that one.
Right.
Sorry.
any redirect.
No, Your Honor.
Thank you, ma'am. You may step down, you may leave, or you may have a seat in the corner. Whatever you'd like.
What?
Call your next witness.
One last witness, Ben Donnelly. Ben Donnelly. Mr. Donnelly, if you'll go around that side, please.
Only raise your right hand and let the clerk place you under oath. Have a seat there.
Mr. Donnelly, please state your full name for the court.
Me and Jamin Stephen Donnelly.
Okay. And how did you know Miss Fanny Rose?
I've been part of the family for 25 years.
Are you married into the family, related?
No,
Just
me and Terry have been together 25 years. They get married.
Scoot up to that microphone just a little bit. Move up. There you go.
so you're friends with the family.
I guess that, yeah, that's what
Okay.
you want to say.
So throughout the time that you have known Miss Rose, did you have a chance to see her handwriting?
Yes, ma'am.
Okay. Did you have a chance to see her, how she signed her signature?
Yes, ma'am.
Okay. If I could have Exhibit 1 passed to Mr. Donnelly.
Let me hand you that. That's Exhibit 1 that we're talking about.
Mr. Donnelly, could you look over that document? Does that appear in your, from the times you saw Miss Rose handwriting, does that appear to be her handwriting?
You talking about everything or just the
Just
signature?
everything. And then I'll ask you about the signature on page 2 next. So look at the handwriting. Does that appear to be her handwriting? And does page 2 appear to be her signature?
Yeah, more so the signature, but like if she wrote her name here on the top and the F's a little, not really like her. It's got an extra that seemed like extra curve, but
Do people's signatures and handwriting change over time?
sure.
Okay. I'd like to submit that as an exhibit to his testimony. Mr. Donnelly, did Miss Rose discuss with you what she wanted to happen with her will at any time?
Yeah, when she was at the house and she was on her
And
deathbed.
do you believe the document that we've submitted to the court is her will to be her desire on what happens to her property?
Oh, no, I didn't read every word of that thing.
Well, you've seen it previously, right?
Seen.
Have you seen her will previously?
Yeah.
Okay. And did you believe it to be what she wanted to happen to her property?
Yeah.
Okay.
It's for
Did you ever have a conversation with Miss Rose about getting rid of a will that she had written previously?
I wasn't. Me and her, I was very aware of other wills that she had that she wanted to do away with, but
Did she say it in your presence? Put it
yeah,
that way.
yeah. Like I said,
Okay.
I've heard them talk about it several times. You know, different
That
scenarios.
she wanted that will, a previous will destroyed.
Several, yeah.
Okay. No further questions, Your Honor.
Mr. Hyman, do you have any questions for this witness?
Mr. Donnelly, so how often were you around Miss Rose where you would have seen her write out her signature or anything else, like handwriting wise, to the point to where you're actually going to be able to point out the little extra thing that she's got on the top of her F for the signature that was lacking on this one here?
You asked me how often. What is your question?
I'm asking you, how is it that you know that her signature is so in detail that you know that there's that extra little thing on her F
Well, I
that
was
she
there
only
when she
does that
signed a couple different times.
that wasn't in this right here, so, as you stated?
I was standing right there when she signed a couple different things on her deathbed towards the end when she was living at our house.
Okay. So she was signing things on her deathbed. And were you aware that she had degenerative disease in her eyes and she could not see anything really with her glasses on, especially without her glasses on?
There was times she could see things, there were times she couldn't. She made it very clear when she couldn't.
So did she have her
She made it very
glasses?
clear when she did.
Did she have her glasses
Read
with
right
her?
out word for word.
Did she have her glasses with her at the time that she was signing all these documents right before she passed?
Don't know. I know she was very aware of what she was doing.
Or is it possible that they're still at my house?
I said, I don't know on the last part. Doesn't make any difference. I know she knows what she was doing. Reading correctly, writing correctly.
So y'all had her signing documents right before her death.
No, she signing on her own. Well, I didn't have her do anything.
No further questions, Your Honor.
Read
No
her
further
out.
questions, Your Honor.
Thank you, sir. You may step down, or you may leave, or you may have a seat in the courtroom. You have any other witnesses?
No other witnesses, Your
You
Honor.
can go back to work.
He has been very patient. He's came with us each time.
All right, so you rested your proof, is that correct?
Yes, Your Honor.
Mr. Hyman, the petitioner has rested, they have rested their proof on this petition to probate this holographic will. You have the right to call witnesses if you wish to. Do you wish to call a witness?
Yes, sir. I'd like to call Chrissy Marion.
All right. What was her name?
Chrissy Marion. She's out here in the hallway.
All right. You'll please step around here, ma'am. I'm going to ask you to raise your right hand and let the clerk place you under oath. This is the witness.
Miss Marion, can you tell me how you know Miss Rose?
Well, she's Granny for one. I've lived with her for the past 2.5 years.
So during that time, you've had the ability to see her signature and her handwriting, correct?
I have.
Okay. Will you please look that over, check out the handwriting and the signature, and tell me if you see anything unusual?
What I do know is that Granny always signed her documents or anything like that with her middle initial. That's what I see right offhand. That's different.
Do you happen to know, did you ever have a conversation with Miss Rose about her intentions with her her estate, her property, or anything after death?
Yes. Granny, I guess it was around end of October, beginning of November. Granny called me in her room and she said that in the event of her death, that, these were the things, and she listed them, what dress she wanted to wear, what we needed to do far as the will. And she told me to get the will immediately
and to get the will to Jake Lockert because he would know what to do. And that Spring Hill, which is the funeral home, they were already arranged. We wouldn't have to do anything but call them because Brad would be too upset to remember everything, and she knew I could, help him remember those things.
Okay, now you said that she called you in her room in October to November, correct?
Yes.
Okay, and that was at her residence at 1313 Randy Road, correct?
Yes.
Not at 175 Dallin Lane
No.
at Miss Pewett's residence, correct?
No.
Okay.
It was at home, at Granny's home, 1313 Randy Road.
Do you know around about when she moved into Miss Pewett's residence at 175 Dallin Lane?
I would say it was around the November-ish. I don't know exact date, but in November, I would think. Because the last time I went to doctor's appointments with her was in October.
Do you have any reason to believe that there was any reason, like that there would be any reason why she would change her wills around? And
She had clear intentions when she brought me up there. And she never told me any different. And she said that it was solely to be for Brad. That she wanted to make sure she was taking care of him and Skylar for them to have a place to live when she was gone. She said that she's the one who started this back when he was a baby, and she was going to finish it. Nobody understood y'all's dynamic, but she understood.
did she ever express to you that she was in fear of anybody while living at her home or her living conditions?
No. Spoke her mind about, to me, about what had bothered her or whatever. So.
Yes, no further questions.
After you have questions.
Okay, so it's your testimony that she said that she wanted to make sure Skylar got everything correct. Okay.
She wanted to make sure that Brad and Skylar had a home to live in after she was gone.
Okay. But the will that's submitted by Mr. Hyman leaves everything to himself, correct?
Yes.
And that was back in 2020, correct?
Yes.
Okay. And in fact, Mr. Hyman that's here today actually has attempted multiple times to sell the home since we petitioned the court to open the estate, correct?
He's following the orders of the reverse mortgage.
Of the orders of the reverse mortgage.
Yes.
But he's never been appointed as anything, correct?
I'm sorry?
He hasn't been appointed as anything, correct? He hasn't.
Not yet.
Okay. And are you aware that Miss Rose was afraid of Mr. Hyman?
No, because she never seemed to be in fear of him while I was there.
You and Mr. Hyman were living in the basement behind 2 deadbolts on a door, correct?
Yes.
To prevent her from accessing it, correct?
No.
And the home that you resided in was so trashed that the codes had Mr. Hyman arrested on 3 occasions, correct?
Not
Who
the
did?
home.
The codes department.
Not the home. It wasn't trashed. It was his business was out in the open,
Okay. Okay.
It didn't have anything to do with being trashed.
And but you lived there and allowed Miss Rose to live in this condition of this property.
What condition are you referring to?
Show me pictures.
Okay. Last time I took her to the hospital, the whole folder's about it.
Okay. I'm going to show you a picture. This is the condition of her feet just walking on the floors. How old was she? 86, if I recall?
She was older, yes.
Okay. And that was the condition of her feet walking on the floors in her home, correct?
I didn't look at her feet.
Okay.
But what I do know is that
may show the court,
we were
please.
having to bring things from outside inside.
Bring outside inside.
Yes.
And then I'll give you the number of items in the home.
This picture that you're saying here is a picture of the decedent's feet after walking
on the floors of her home.
That's in
But,
the emergency room, Your Honor. No, I
You
took
can't
her.
say anything. I'm
Sorry.
not sure who you are.
Sorry.
That was her feet when she came out of the, when they took her out of the home to take her to the
Put your
emergency room.
hand down, Mr. Hyman. This is cross-examination.
Okay. Now pull up the picture of all the items in the home.
Granny, he's had salts and stuff. Salts.
Let's not do the video. Show me the picture. I just want
She
to
never
show
was
a brief.
barefoot.
These. This is okay. 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 Showing that picture, please. And that's just one room in the home of all the stuff that was in the home, correct?
Yes, this is where this is the very back room, and that's where they would store like their yard. When this is like way back, this is like 2.5 years ago or something.
Okay.
But this is where they would store the things that they wanted to yards. They were like junkers. They like to, sell things. That's how they made their money. Like
Mr. Hyman's a junker.
Granny too. She would say, sell it. Sell
Like
it,
to show the court that picture.
But yeah, that's where they would put the stuff that they were selling, like yard sales and stuff.
Okay. So it's your testimony that Miss Rose wanted everything to go to Skylar, correct?
No, not everything to go to Skylar. She
Well,
wanted Skylar taken care of.
Okay. No further questions.
Thank you, ma'am. You may step down. Mr. Hyman, do you have any other proof?
I'm not entirely sure. I do have, like I said,
Stand up when you're talking and go to the podium.
I do know that I had spoke to Margaret Brady, and she was going to, she was here, I guess, was going to testify that she had spoken with my grandmother sometime around 2021, 2022, that she had intended on changing some of her will, but she fully intended to still leave me a sole beneficiary.
Your Honor, I object to hearsay.
Sustain the objection.
Can I say something about what she was just saying about leaving everything to me and Skylar? That the will that I submitted actually states.
You want to testify, you're going to have to be under oath.
That's fine. That's fine.
Pardon?
Yes, that's fine.
All right, come around here. We'll put you under oath. Raise your right hand and be placed under oath.
Okay, so what the will that my great grandmother submitted, it states that I'm to receive the entirety of her estate with my son as a predecessor in case I was deceased prior. But she did so because her and I had talked about this so many times that she knew that I was going to take care of my son, that I was going to have a roof over his head. He was living with me at the time and not with his mother. He lived with me for years actually and refused to even go back to his mother's house. He's only recently went back there. I love my great grandmother. She raised me, and really, I don't even care about him. I'd much rather have her here than have. But I do know that Miss Pewitt and Miss Dowling were absent in my great grandmother's life for years upon years upon years, and has only just recently surfaced back up in her life over the past few years. They practically disowned her for forever. And I do know that the will that Tucker drew up in 2020 that was set in stone only became questioned and started getting brought back up again after Miss Pewitt resurfaced in my great grandmother's life. I do know that my great grandmother started getting a lot more stressed out, and money started becoming more of an issue. And I was having to work extra. Myself and my fiance was having to go work extra just to try to pick up the bills because there would just be money going missing every month. Miss Pewitt had my grandmother put on her bank account, and Social Security check was missing, and the bank account hacked. And we had to pick the slack up on that. I know that my great grandmother opened up a U.S. bank account, and it was going just fine. She puts Miss Pewitt on the bank account, and then bank account's hacked again. And
well, you need to focus your testimony on whether or not you believe this was a valid will.
no, sir, Your Honor, I don't believe that's a valid will at all. If you look at the signature at the bottom of it, it's what they call a stipulated forgery. It's where you take a piece of paper and lay it over top of it, and you put
Your
the
Honor, I
imprint in it.
object to hearsay. There's no expert to testify this.
Okay, if you look at
Sustained, you can't testify about what AI or anyone else said unless you bring in some expert to testify, which you'll have the right to do.
but I can testify as to what I see, right?
You can testify what you see.
Okay, well, from what I see, everything throughout the writing, I'm not arguing that that top part was written by my grandmother. I'm going to say that is 100% written by my granny. She had a thing where if she got upset with somebody over the years, she would sit down and she had this pad and she would just write instead of going and calling the person out and causing a big problem or anything like that. She would sit down and she would write. And that's why she never signed the bottom of them at all. And that's why there's so many that just managed to keep popping up. And as Mr. Donnelly even said, that she said that she had a multitude of things that she needed to just cancel out prior. She had mentioned to me that she wished she had them all back in because she had no clue what they all said, and she didn't want exactly this happening. However, I know that when I'm looking at that paper, the whole top part is written with more of a fine tip pen and dark black, and it's fluent. It's perfect cursive. Like she was comfortable. She knew what she was doing. And then I look at the signature at the bottom, and it's not Fannie M. Rose. It's not Fannie Mae Rose. Like she normally signed all of her legal documentation. Anything that had to do with doctors, lawyers, anything was always signed with Fannie M. Rose or Fannie Mae Rose. And all I'm seeing is Fannie Rose and a different shade, different width, and different pressure, stroke. I mean, it doesn't look like it fits the page at all. And that's just me personally. That's what I'm seeing there. I know that it's bothered me for the last few years that everybody's been so worried about asking my granny for the will and trying to. Everybody's just been worrying about what they're getting when she's gone. She's still here, and this is. Everybody's just worried about money and selling the house, and as they were saying that I've been putting the house up for sale and the reverse mortgage. They tried foreclosing on the house. They put the house up for foreclosure and stuff because nobody was moving along. I've been in contact with them since my great grandmother passed, and in order to get an extension on the
Your
payoff,
Honor, I object to the hearsay.
Can't repeat what somebody else says. Is there anything else about this will, the execution of this will, that you wish to be heard about?
I was just trying to explain why they're saying that I got the house up for sale. I put the sign up because I had to put
that doesn't make it more or less true that this is her valid will.
I'm just saying that that will there, to me, Your Honor, the ink doesn't match up. You know, I mean, I've never known my great grandmother to ever want like.
Under this will, she leaves you $100, and then she leaves the remainder of her estate in 1/3 each to your. Is that your son Skylar?
Yes, sir. That's my son Skylar.
He gets a Skylar with this thing.
I tried to get him to come in and testify as well. And
You get $100. Terry Pewitt, Ashley Dowles, and Skylar Heineman are to get 1/3 of the money left.
Yes, sir. And which is
so she took care of your son in this will, right?
And that, yes, sir. But that's allegedly. But I don't, because I can speak an opinion on the person that's left in charge. But it alters if you look from the original one, which there's another will somewhere in there, but we weren't unable to locate it, and it left Ms. Pewitt and Miss Dallin $2,000 a piece out of the life insurance policy, but we have not been able to find it. Somebody actually came into the house and it's gone along with a lot of other paperwork that was in there. But I tried to get my son to come in and testify, and he said he wouldn't do it. He wasn't contesting the will, whatever. But what I do know is that I don't think it's a drastic change from 2021 from 2020. While I've been still living in my great grandmother's house, I was taking care of my great grandmother. I stayed there. That's why they didn't know that she had glasses. That she had to have her
So
glasses.
is she your grandmother or your great grandmother?
It's my great grandmother, sir. She raised me as her own because Miss Hewitt basically handed me off to her when I was born, and she's raised me, taking care of me my entire life. I've lived with her practically my entire life.
Okay, you've made it clear that so are you saying that a will that was executed in 2020 is the correct will?
Yes, sir. I'm saying that that's the only correct will, and that's why she went and she actually paid to have it done.
This will in 2023, you're contesting that that's her signature.
Yes, sir. I'm saying that she wrote that while she was mad at the top.
So you're saying she did write?
She wrote the top, but she did not sign the bottom of it, and she knew not to do that because when my Aunt Jackie died, there was a thing with something that didn't have a signature, so it was proven invalid in court. But
So
I'm saying
are you saying that she wrote that provision that I just read you, where she gives you $100 and leaves your son a third of the estate? Yes. She did that because she was mad?
Yes, sir. But if you look at the second page,
who was she mad
at? I'm assuming at me at that point in time.
And she said you got your tools, right? All your tools.
Yes, sir. I have a lot of tools, but she also said something about the furniture. But if you look at page 2 of the will that was presented in 2020, in the second paragraph, it states that she can write a letter.
I'm not looking at the will in 2020 because it hasn't been produced for me to consider. I'm only considering this, whether or not this is her valid will. It's 3 years after the 2020 will, and if this is a valid holographic will, then it revokes that prior.
I'm telling you right here and now that that's not her intentions. That's not her signature on it. Somebody added
All right,
that
Ms.
signature.
Crabtree, you may cross-examine.
No questions, Your Honor.
Step down.
Sorry.
The petition that's before this court is to determine whether or not this holographic will should be admitted to probate and whether or not to admit that will and appoint the petitioners Terry Pewitt and Susan Valentine as the administrators or the co-executors of this estate. Based on the statutes that are involved and the testimony before me, I find that the credible proof has been that this is in fact the handwriting of the decedent in this case, and that that is her signature on both of those, her handwriting and then her signature, and that it has been properly authenticated as being a holographic will pursuant to statute. That will provides that the petitioners Terry Pewitt and Susan Valentine should serve as the co-executors, and I will appoint them to serve under those provisions. Now, Mr. Heineman, you are arguing that that's not her valid will. It shouldn't be. Are you on any kind of medication today?
No, sir, I'm not. What I am is I'm.
How old are you?
I'm 35 years old.
All right, 35 years old, then you should know how to behave in a situation like this and quit acting like you are having a nervous breakdown. But I'm telling you, I understand you're upset, and I understand you may not like my ruling. The fact of the matter is I have made my ruling in compliance with the state law, and if you disagree with it, then consult an attorney, hire an attorney, and file a contest to the will to show what you believe to be the valid will. There are other bases upon which you can contest the will, such as undue influence. If you think somebody's influenced your grandmother to execute that will that more or less leaves you $100, then you can make that argument. But right now, you're saying a will that she executed in 2020 is the one that ought to be there, and you haven't produced that will. Second thing is, this is a 2023 will, and I have ruled that it has been the statutory requirements have been met to establish it as a valid will. That is the ruling of the court. You may consult an attorney about your options from here.
I have a question. Did Jennifer know? Jennifer said that she submitted the 2020 will to the courts prior to the last
I haven't
time we
seen
were
the
here.
2020 will, or if there is one, I didn't. It was not promoted by anyone.
She
So.
said that.
I believe a copy was submitted, John.
All right.
Yes, sir.
That concludes this hearing. So you may consult an attorney and see what other options you have. So. Where are we on the Gerald Gish?
Yes, John, we're ready to proceed.
Pardon?
Ready
All right.
to proceed.
We'll see you at 1 o'clock. We're breaking for lunch until 1 o'clock.
All rise.
Hey, Rhonda, if I go do the order and Judge is able to sign it, when he comes back, can she sign this afternoon? She lives in the White House, so. Oh, thank you. I'm jealous of this one.
Oh, I thought you were talking to me.
Oh, yeah. Is he gone?
I haven't heard. Jeez.
Oh, like I mentioned, I'm downstairs. I forget. Sorry,
I still have at least 100 pictures I can show. A video, everything. Y'all can just sit around that picture.
I can't imagine everyone saying
I'm pretty good.
what about the house. There ain't like not much of
There's, I hope there is. Yeah, it's got a reverse force.
No. No, he just wants to get the work extras. I ain't worked today.
His kids getting a fur. Oh, he don't want him to have none. He'll take his birthday. You guys, he won't take his birthday. He put a sign on the tree outside of it up for sale.
Okay, to go.
We'll try.
Well, I want to fail to be congested.
I didn't think else to speak about. It's their face.
Are you leaving this open or do I need to get out?
So cold.
Yeah, Judge just asked us to try to get it turned up.
Thank God. I mean, these are so cold. Look at this. They're not.
John, you good, bro?
Here, come on, let's go.
We're
not gonna.
They,
We're
they,
leaving.
they just got sent to lunch until 1.
I'm not sure if they're gonna take them to lunch or what.
Okay.
I imagine they have to get the lunch break soon.
Yeah, they do. Yeah, they do. That's what I don't even know why they were grabbing the other deputy to come talk unless they get some.
No, it's.
Okay. Nothing like having, I guess they'd help you stay awake anyway. So. All right. So we're down to the Gish versus Privet. Is that correct?
No,
That's not it.
Privet. Well, I mean, that's the case, but Gish is the decedent and Privet is the executor. This is on a claim by Mr. Hadley.
In the matter of Gerald Gish. Okay.
Yes, Your
So you want to explain to me what we're
First, I'd
arguing over?
like to call for the rule, please.
Rule has been requested, so anyone who's going to be a witness in this case other than the parties must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You're not to discuss the testimony of any other person until you yourself testify. So. All right, you ready? This is it's a motion or a petition to vest a real property into the estate.
Yes, Your Honor.
And a claim.
Yes, Your Honor. These pleadings coincide with each other. I represent the creditor on the estate, Marcus Hadlock. He filed a creditor claim on this matter on March 19th. It's a substantial amount because this involves a business loan with the SBA. Mr. Hadlock is a decedent's former business partner. He's present today and will testify in support of his claim. The estate filed an exception to this claim on April 16th. And that's why we're here. And if this court grants the exception to the claim, that makes the petition to vest the property into the estate moot. So that's why they coincide.
All right, so it's an exception to the claim. So if you want to present your evidence on your claim, I'll be glad to let you put it on.
Thank you, Your Honor. The creditor calls Marcus Hadlock to the stand.
All right. Step around here. I'm going to ask you to raise your right hand and let the clerk place you under oath. All right, go ahead.
Okay. Please state your full name for the record, sir.
Marcus Lee Hadlock.
And how do you know the decedent, Mr. Gerald Gish?
We were former business partners, and he was my father-in-law.
Okay. And what businesses were you involved in together?
Roofing company and a sign/wrap company.
Okay. And what were the names of those businesses?
At the Top Restoration and Twisted Concepts.
Okay. With the first business you mentioned at the top.
Actually, there's another business. We owned a bar together as well.
Okay. The first business you mentioned, Mr. Hadlock, at the Top Restoration LP, is that correct?
Yes. It was an LLC
Okay.
at one point too. I'm not sure when it transferred.
Okay. What was the structure during Mr. Gish's lifetime of that business?
We were 50-50 partners.
Okay. Were you still partners when Mr. Gish passed away?
No.
Okay. What happened to change that structure?
I bought him out of the bar and he bought me out of the roofing company and the sign company.
Okay. Mr. Hadlock, I'm going to have the bailiff present you a document that was filed that coincides with your creditor claim that was submitted to the court. It says at the Top Restoration LP membership interest purchase agreement. Did I read that correctly?
Yes, you did.
Okay. And did you sign this document?
I did.
Okay. Did you work in a capacity with Mr. Gish where you could recognize Mr. Gish's signature on documents?
Yes.
Okay. Based on your knowledge, did Mr. Gish sign this document as well?
Yes.
Okay. And what is the significance of this document?
This was our buy-sell agreement.
So that's the document that reflects you being bought out of the first business you mentioned at the Top Restoration?
Correct.
Okay. I want to direct you to paragraph 3.4 of that document. Can you read section 3.4 into the record for the court?
Upon the execution of this agreement, all debts belonging to the company shall be assumed by the company in the event of bankruptcy is filed at any time after the execution of this agreement. The company will assume the debt.
Okay, and then I'd like to direct you to paragraph 7.1 of that document as well.
Okay.
And can you read that paragraph into the record, please?
Purchaser agrees to be responsible for all indebtedness that is in the name of At the Top Restoration or any of its derivative names or aliases. Purchaser shall also be responsible for any business-related debts that are in the individual names of Gerald Gish and Marcus Hadlock.
Okay,
except for the following.
and can you clarify for the court who the purchaser is in that agreement?
Gary Gish.
Okay, and I'd like to have you go down to section 8.1 of that document as well.
Okay.
Can you read that for the record, please?
Successor's assignment. This agreement shall be binding upon and shall ensure to the benefit of the seller and their respective executors and administrators and of the purchaser and its respective successors and assigns this agreement and the rights and obligations hereunder shall not be assignable without the prior written consent of other parties hereto.
Okay. Thank you, Mr. Hadlock. Your Honor, I'd like to admit that document as Exhibit 1 for the testimony today.
We'll mark it as Exhibit 1.
Okay. Mr. Hadlock, you just read into the record language from a business document regarding business debts. Is that correct?
Yes, sir.
Okay. Were there business debts that you were aware of prior to your departure of that first business?
They were listed in the agreement.
Okay.
There was Supply House.
Okay. And in that document, it also references your membership interest in the second business you mentioned previously, Twisted Concepts LLC. Is that correct?
Yes.
Specifically on page 10, there's a chart that shows assets being transferred, correct?
Yes.
And on that chart, it shows your membership interest being conveyed to Mr. Gish at that point in time in March of 2021. Is that correct?
Yes.
Okay. What was the second business you talked about earlier, Twisted Concepts LLC? What type of business was that?
Signs and vehicle wraps.
Okay. Do you know if that business is still active to this day, to your knowledge?
No, I don't believe it is.
Were you involved in that business at the time of Mr. Gish's death in 2025?
No, I was not.
Were you bought out of that second business as well?
Correct. Yes.
Do you recall around what time you were bought out from Twisted Concepts LLC?
I believe it was in March.
Okay, of 2021, based on that first document that
Correct.
referenced your membership interest. Mr. Hadlock, after counsel reviews this copy, the deputy is going to show you another document. This is a document that's labeled Twisted Concepts LLC Membership Interest Purchase Agreement. Did I read that correctly?
Yes.
Okay. And what's the date of that document?
November 12th, 2021.
Okay. Mr. Hadlock, what was your understanding of what this document did?
This, I believe, transferred all my interest over.
Okay. Of Twisted Concepts.
Correct.
To whom?
To Gary.
Okay.
Gary Gish.
Okay. Can you read for the record section 7.1 into the record from that document, please?
Yes, debts. Purchaser agrees to be responsible for all indebtedness that is in the name of Twisted Concepts or any of its derivative names or aliases. Purchaser shall also be responsible for any business-related debts that are in the individual names of Gerald Gish or Marcus Hadlock.
Thank you, Mr. Hadlock. Can you go down to section 7.4 and read that as well, please?
taxes, the parties agree to evenly split all business taxes.
Right. Mr. Hadlock, 7.4.
That is.
That
Okay.
is 7.4.
There's two 7.4s listed on that page.
Oh, okay.
I'm asking for the second one.
Okay. Any other financial obligation, purchaser agrees to remain responsible for any related business debt incurred July 1st, 2020 going forward, which could be associated with Twisted Concepts.
Thank you, Mr. Hadlock. And section 8.1 of that document, is that the same similar language from the first document we referenced dealing with successors and assigns?
Yes.
Okay. Your Honor, I'd like to enter that document as Exhibit 2 of the testimony today.
It is Exhibit 2.
Mr. Hadlock, we've talked about debt obligations for two business entities that you got bought out of in 2021. Is that correct?
Yes.
During your time with your involvement with Mr. Gish in these businesses, do you recall any loans being taken out from these businesses?
Yes.
Were any of these loans taken out from the SBA, the Small Business Administration?
Yes.
Which would you be referring to, the At the Top Restoration or Twisted Concepts?
I believe they were taken out on both of them.
Okay. Tell us about those. What do you remember from those?
That they were taken out on both businesses.
Okay. Do you recall assuming personal liability for any of those loans for those two businesses?
No.
Okay. Mr. Hadlock, you have filed a creditor claim on this estate, Mr. Gish, related to an SBA loan from the second business, Twisted Concepts LLC. Is that correct?
Yes.
Okay. And do you recall what the amount was for the loan in question that was taken out with the SBA?
I think it was $500,000.
Okay. Now, in the document submitted to this court in the estate, the amount you're requesting in this creditor claim is larger than that. Is that correct?
Yes.
Okay. Do you recall preparing an affidavit in support of your creditor claim that was filed with this court?
Yes.
Is everything in that affidavit still true and correct to the best of your knowledge?
Yes.
Okay. Mr. Hadlock, have you been contacted by the SBA seeking payment for this business loan?
Yes, multiple times.
When?
Going back to when Gary was still alive.
Okay. Give us a time frame, a year.
Yeah, I would say a year.
Well, give me a specific year when they first contacted you requesting payment for this loan. Was it 2023, 2024?
I would say it's probably a year after we split.
So 2022.
No, actually it was longer than that. Within the past couple years.
So 2024.
Yeah.
How did the SBA contact you?
They sent me letters in the mail, and then I called them after I received the letters.
Okay. Did you ever attempt to resolve this issue with this SBA loan with Mr. Gish during his lifetime?
Yes.
Okay. Did you notify him of this issue with the SBA loan?
I did.
Did you express your concerns about being demanded payment by the SBA for this loan personally?
Yes, I did.
Okay. What do you recall from those discussions?
Your Honor, I'm going to object to your statement.
I'm not asking for the truth of the matter asserted. I'm asking what do you recall based on the circumstances of that?
If what he recalls that the decedent said.
Yeah.
I'm not asking for what exactly was said. I'm asking for the circumstances.
I'm not sure what the circumstances, how the circumstances can be explained without. Let him answer the question.
Okay.
I'll consider.
I'll withdraw. Mr. Hadlock, do you have any knowledge of whether Mr. Gish made any payments toward this business loan?
Yes, I believe he did.
Okay. Do you recall being served with emails about this loan from the SBA?
Yes.
Okay. I'm going to show you another document that you actually provided to me. While we're waiting on that document, Mr. Hadlock, have you made any payments out of your own pocket toward this SBA loan?
No, I have not,
Why not?
because it's not my loan.
Do you have other loans that you've taken out on your own with the SBA for your other businesses or yourself?
I do.
The deputy's going to hand you this document that you actually provided my office. It's an email from August of 2025. Do you recognize that document?
I do.
Okay. And what is your understanding of what that document is?
Your Honor, I'm going to object. That's hearsay. I don't know. I mean, that's just an email that he received. I don't know.
It's authenticating his prior testimony about being served by notice from the SBA regarding this
Your
loan.
Honor, he would have to have the person that sent it here to testify. That's just the.
It's not an individual person, it's an entity.
But what is said in that document is true. That is, he's been contacted. He's testified he's been contacted by SBA. So I think he's established that through his testimony.
That's fine.
If some cross-examination occurs that casts that in a light where you need to substantiate it, then I will reconsider, but I'll sustain the objection.
Thank you, Your Honor. Mr. Hadlock, have you been served with other notices from the SBA or any other third party on behalf of the SBA regarding this loan?
I have.
Okay. What third parties have contacted you about this?
The SBA itself and a collection agency that works with the SBA.
Do you recall the name of the debt collector?
I don't.
Okay. Does the name Conserve sound familiar?
Yes.
Okay. Mr. Hadlock, just to refresh for the court, you have filed a creditor claim for the amount of this business SBA loan as well as the interest that has been demanded by the debt collector from the SBA. Is that correct?
Yes.
And this loan is still accruing interest to this day, correct?
Yes.
Okay. Why have you filed a creditor claim on this estate?
To cover the payment on the loan or the balance on the loan.
Okay. But you just testified that you have not made payments toward this loan, correct?
Correct.
Okay. All right. You've also filed a petition to bring Mr. Gish's home, his real property, into this estate to pay off debts, including this loan. Is that correct?
Yes.
Why have you taken that position to make that request to this court?
To cover the balance of what's owed.
Okay. Do you have any knowledge of whether Mr. Gish had any other assets that could pay off this business loan?
He owned various vehicles and I wasn't really privy to everything that he owned at that point.
Okay. Based on your prior knowledge and involvement in the joint businesses of Mr. Gish, or do you know if those businesses have any assets that could go toward its business loan?
Possibly. Like I said, there's vehicles and different random things.
Okay. I turn to the witness, Your Honor.
Mr. Willoughby, do you need anything in particular, or is this just observation?
We have grand jury today, and usually they do a jail tour, but since today's the day that they're moving inmates over to the new jail from the old jail, we thought it was probably safer to just tour the courtroom part.
I'm not sure it's that safe in here, but you're welcome here. Well, let me put it this way: unless you come over here, you're safe unless you come over here and sit under this air conditioning bed.
I was telling them we just had the sheriff's department had a mock trial in-service training. One of the days I was sitting where you are. I'm not as smart as you. Put that out there. I got a pretty heavy dose of the AC.
We'll figure it out. May have to break up some furniture and start a fire here.
Hey, we found the thermostat.
Oh yes.
So far, it has not made much of a difference.
It's getting there over here. Sorry.
Right.
All right. We'll get out of here.
Just a minute. No, you stay as long as you want.
No, have fun.
I'm not objecting. I just didn't know if I needed to do anything for you.
No.
All right.
Thank you, Your Honor. So you stated that at the top, when you purchased it, you actually, in fact,
purchased Twisted Concept, correct?
No.
No. Purchase price for membership interest in Twisted Concepts LLC. Your Honor, could you hand him back Exhibit 1, please? I'm going to direct you to the next to the last page. That'll be page 10. Under Chart B, the very last thing, purchase price for membership interest in Twisted Concepts LLC, $5,000. Is that what happened? You you sold your interest to Mr. Gish in Twisted Concepts LLC at the same time you sold your interest in At the Top, correct? Okay. So after March 1st, 2021, you no longer owned any membership or interest in Twisted Concept. Is that correct?
We had to do the second contract that I believe were the final signatures where I transferred everything over.
But you'd already sold it, correct? That's what this says. Purchase price. You sold it. Y'all went through, if you go back and look, 7.4 on the taxes, y'all dealt with the taxes for Twisted Concept LLC, correct? I'm sorry, LP.
Yes, correct.
Okay, so you had already sold your interest in Twisted Concept in March, correct?
Yes.
Did you have any more to do with the business after March 1st when you sold At the Top?
No, I did not.
Okay, so you were done with Twisted Concept. I'm going to hand you up another document, and I'm going to ask you to look over that. Do you recall that document?
Yes.
What is that document?
The debt obligation agreement.
So it's a debt obligation agreement dated November 11th, 2021, and it was made between you and Mr. Gish, correct?
Yes.
And it says, whereas Mr. Gish owns 100% membership interest in Twisted Concepts LLC, correct?
Yes.
And you, Mr. Hadlock, is a former member of Twisted Concepts LLC, correct?
Yes.
And it goes on to explain that you and Mr. Gish had taken out an SBA loan, correct?
Correct.
And it says that the loan number 999-8689-006 in the amount of $500,000 is this SBA loan that you and Mr. Gish took out together, correct?
Yes.
Okay. And that's the only SBA loan that we've seen referenced in any of these contracts, correct?
Yes.
One SBA loan, $500,000, correct?
As far as I know.
And it further goes on to state that y'all are going to split that 50-50, correct?
Correct.
And it even sets out Marcus, $229,934.97. And Mr. Gish, $254,560.14, correct?
Correct.
Did you pay any payments on your $229,000 that you owed?
No, I did not.
Why not?
That never came up between us.
But you owed it, correct?
As far as I remember, yes.
And you signed this form. That's your signature on the last page, correct?
Yes.
Okay. So you acknowledge you owed half of 500,000 SBA loan number 998689006. Correct?
Yes.
Okay. If you'll, Your Honor, I'd like to admit that.
That would be Exhibit 3.
You still have Exhibit 1.
Yes.
Can we look at page 11 of Exhibit 1? Do you have that? Do you have that in front of you?
I'm pulling it up.
It's the very last page.
Okay.
Seller Marcus Hadlock shall make a $100,000 down payment at closing. He will then pay the balance of $230,000 over 84 months, equal $2,738.10 a month, due the 15th of each month, with the first payment starting in April of 2021. Did you make those payments?
I did not.
You've made none of those payments?
We owned a.
Yes or no, sir?
No, I didn't.
Okay. And it also states that there's a promissory note associated with this. Did you sign a promissory note at the time of the closing?
Possibly. I don't recall.
Okay. I'd like you, I'm done with that. You can pass that one to Your Honor. Your Honor, I'm not sure which exhibit the conserve, did they provide you a copy? Did they admit into evidence a copy of the notice?
I have Exhibit 1, which is what he's been referring to. Exhibit 2 is the Twisted Concept LLC membership interest purchase agreement. And then your Exhibit 3 is your debt obligation agreement. You go. Exhibit 1.
I'd like to pass this up to the witness, please. Now, is this the notice or the proof that you provided in your claim of the SBA loan that you want Mr. Gish's estate to pay?
It's one of the notices, yes.
Okay. And I'm assuming this was the most recent is why
Is this the notice you objected to?
No, sir. No, sir. No. This is attached to the claim. Your Honor has it in his file. It was their proof of the claim.
Oh, thank you.
Yes, sir. So this is what you're filing, saying that this is the SBA loan that you are asking the estate to pay, correct?
Yes.
And it's in your name, Marcus Hadlock, right?
Yes.
And there's no business name associated with it, correct?
Correct.
There's no breakdown of when this loan was taken out, correct?
Correct.
And it actually has a loan number. You had a COVID EIDL loans from Small Business Administration with the account number. Can you read that account number, please?
$222 22730.
Well, that's not the same SBA loan account number that you had testified to earlier was the loan y'all took out, correct?
It's not the same number.
So this is a totally different account number
Yes.
in your name, correct?
I don't have any other loans that aren't. I have one SBA loan and it's current. I receive a statement every month after I make a payment.
Well, again, this one is in your name. It's not the same account number that we've already dealt with and that y'all put in paper, in writing, in the contract, in the agreement that this is the SBA loan, this is the one we're paying, and we're splitting it 50-50, correct? This isn't it.
I don't have any other loans
Okay, so
that are not satisfied. and current.
Did you inquire with the SBA about this?
This just came up. I wasn't aware of the different numbers.
So you've just been rolling on assuming that this must be because you didn't do it, correct?
I didn't do what?
Take this loan out.
Correct, I didn't.
So you just assumed it came from Mr. Gish.
No, I actually spoke with the SBA when I called them and sent them copies of our paperwork before they turned it over to a collection agency.
Okay. And did they send you something showing exactly where it transpired from?
This was later on. Initially, it was
That's
just
not
the
my
SBA.
question. Did the SBA send you anything showing where this loan came from? Who applied for it? They either did or didn't.
I don't recall. I would have to search for it.
Okay. So as we sit here today, you have no proof that Mr. Gish, Twisted Concepts, at the top, anybody took out this SBA loan, do you?
The SBA has contacted me about the loan.
That's not my question. My question is, as we sit here, you sit here today, do you have any proof that this loan was taken out by Mr. Gish, At the Top Restoration, or Twisted Concepts?
I don't know if the
Yes or
credit
no?
agency,
Do you have any proof that those three did apply for this loan?
I don't know if they use a different account number for the collection agency.
Well, it
But
says
the
right
balances
here,
are the same.
Small Business Administration with account number. It tells you the account number from the Small Business Association.
Ma'am, I have no other loans.
And we don't know, so we don't know where this came from.
They came from the SBA. It's a collection agency.
I understand, but we don't know who took it out. Who borrowed this money? Where is your proof that Mr.
It's in all
Gish?
the documents.
Who prepared these contracts?
Cobb Law Group.
Now, you went over the Twisted Concepts. Strike that. That's all I have, Your Honor.
Redirect, Your Honor, briefly.
You got it.
Mr. Hadlock, the attorney for the estate raised a concern about the different numbers on the documents, correct?
Yes.
Okay. And she also asked you if you have made efforts to contact the SBA or the debt collector about that. Do you recall that?
Yes.
Okay. Did you retain my office to assist you with that issue?
I did.
Okay. I'm going to show you a document after counsel reviews it. Just to confirm with the record, Your Honor, is Exhibit 4 the notice from the debt collector that counsel for the estate admitted into the record? Your Honor?
I'm sorry. Go ahead. I was reading.
Yes, I apologize. Is Exhibit 4 in your record the notice from the debt collector that counsel for the estate just admitted previously?
You have Exhibit 4. I only have Exhibit 3.
Were you wanting to admit that?
He should have.
Okay.
I asked that it be admitted.
It hasn't been marked. Do you have it?
It was the conserve.
Oh. We'll mark that as Exhibit 4.
Sorry for the confusion. And we're referring to the numbers in Exhibit 4 that are different from the SBA loan number, correct?
Yes.
Okay. Do you recognize that document in front of you currently?
I do.
Okay. And what is that? What is your understanding of what that document is?
That's the correspondence with the SBA from your law office.
The notice from my office to the debt collector regarding this loan.
Yes.
And on the top of that document are the numbers from Exhibit 4 listed in bold.
Yes.
And at the bottom of that first page, the number for the actual SBA loan that we just saw in your debt obligation agreement is listed in that same document, correct?
Yes.
Okay. So, and you've just testified that you have no other loans with the SBA, do you?
I do have a loan with the SBA, but it's current, and I receive a statement every month after a payment.
But you have no loans, either personally or your other businesses, that are past due for a debt collector to collect on from you.
Correct.
Okay. All right. Mr. Hadlock, have you submitted a records request to the SBA or Conserv regarding this loan?
Yes.
Okay. And have you received documents from them as of today?
No.
That's all I have, Your Honor.
Can I?
Go ahead, Mr. Hadlock.
So I wanted to address the payments earlier.
Yes, sir.
Mr. Gish and I owned a commercial piece of property together, and our agreement on the property is we split the payments and we split the taxes on it. Mr. Gish never paid. Well, I don't want to say never. In the beginning,
I'm gonna object. All of this is hearsay. There's.
it's payments that I made in this agreement that I had.
Hold on just a second. I have an objection. It's not hearsay if he's saying that that Mr. Gishany had an agreement, but that he's never paid this portion of the agreement, or as he was about to say, he won't say never, but he's saying apparently that Mr. Gish didn't pay. I'm going to let him finish his answer, and we'll consider whether or not it amounts to any objection.
Yes, sir.
Go ahead.
So Mr. Gish and I owned a commercial piece of property together that since I bought him out of, but prior to buying him out of the property, once we split for a short period of time, he made his payments and then he stopped making his portion of the payments and he did not pay his portion of the taxes. So we had unresolved monies between he and I in the payments.
Mr. Hadlock, an issue before this court is the petition to bring Mr. Gish's personal home, his real property, into this estate to pay off debts like this, correct?
Yes.
Okay. Do you have any personal knowledge from your involvement in the businesses what the money from this loan was used for?
To purchase the home.
And do you have knowledge of what other assets were purchased from this loan?
A tree business.
The SBA loan?
Yeah. Yes, Your Honor. Mr. Hadlock, in your creditor claim form that you submitted to this court, you asked for the full debt to be paid by the estate, over $753,000 that's still accruing interest to this day. Is that correct?
Yes.
Okay. Can you remind the court why you're asking the estate to pay this SBA loan instead of you?
That's what was in the agreement.
Okay. No further questions, Your Honor.
The agreement actually says that you would not be responsible for paying his portion of that SBA loan, right?
Yes, sir.
We'll stipulate
basically that what I'm reading is, in the event one of the parties were to predecease the other, the surviving party, you're the surviving party, right? Surviving party shall not be responsible for the deceased party's debt obligation on the subject loan. This agreement shows that his debt obligation was $254,560.14. Yours was $229,934.97. So the estate of the deceased party and the deceased party's heirs and assigns shall be solely responsible for the repayment of the deceased party's portion of the subject loan in accordance with the loan repayment terms. So I guess I'm wondering, why do you think that the entire $500,000 plus loan plus interest would be, assuming your argument is that he should be responsible for paying for the SBA loan as a claim against his estate, and you're being asked to pay it? Wouldn't this document say that the maximum amount you could get would be $254,000, not $500,000? I probably ought to put that to your lawyer rather than you. You understand where I'm coming from?
I do.
You got an answer for that?
Sure. We would direct the court to the language in the actual buyout agreements in Exhibit 1, Exhibit 2 that say the business debts, including this SBA loan, that was a business debt obligation that were assumed by Mr. Gish and the business themselves in full. So we have documents that have conflicting language during the relevant time.
Point me to the language section of the file.
Yes, Your Honor. We can start with
Exhibit
is Mr. Hadlock's position that this specific loan was taken out for Twisted Concepts LLC, the second business. So we would defer to Exhibit 2. The language specifically would be 7.1, 7.4, and 8.1. 7.1 and 7. The second paragraph in 7.4 shows that Mr. Gish himself, as the purchaser and the business, assumed full responsibility for any business obligations. And Section 8.1 binds that agreement for successors and assigns or surviving parties of the decedent. And we acknowledge that there is different language in Exhibit 3, the debt obligation agreement, specifically regarding this loan. But now we have the battle of the documents.
All right.
No further questions for the witness, Your Honor.
Any read cross?
Your Honor, just to that discussion that was had, my position would be that.
Do you have any other questions for him? He's sitting here on the witness stand. I want to get him off.
I understand.
If you're finished with him.
Yes, sir. Going back to the petition to bring the property in, do you have any proof that there is not enough personal property to pay any claims against the estate?
Do I have any proof of the financial status of the?
Correct. You're asking that all the real estate be sold so that if your claim is granted, if it's not accepted to, that the real estate has to be sold to sell that. Well, do you have any proof showing that there's not enough personal property to do that?
I was aware of the financial situation that Gary was in.
How were you aware?
We had spoken about it.
Before or after he sold his business to you?
After.
Before he passed?
Correct.
So you know all of his business situations?
We were partners and he was my father-in-law. We discussed a lot of things.
But y'all ended the partnership in 21. No more
Correct.
Partnerships in 2021.
Correct. Except for, besides the property we own together.
Correct. Do you have any documentation about this property, this commercial property you're saying that you testified about?
Yes. I'm not here today.
Okay. That's all I have, Your Honor.
Anything further?
Nothing from this witness, Your Honor.
Thank you. You may step down.
Creditor calls one last witness today, Jordan Hunt. He's out in the hall.
You're gonna hand that back.
I can't listen. Okay, that's not. What is this? One sign was. Yeah, I don't have that contract. That's the one he's talking about.
Yes.
What is it?
That was the letter we had Mr. Hadlock testify to, or my office's notice to the debt collector.
All right. Go ahead and mark it as exhibit 5. You'll step right up here, please, ma'am. You'll raise your right hand and be placed in the air.
Yes, ma'am.
Please state your name for the record, please.
Jordan Hunt.
And how did you know the decedent, Mr. Gerald Gish?
I worked for him as a secretary.
And how long did you work as his secretary?
I started in 2017 and then I stopped working for him in like 2024 after he went back home after being sick.
Can you describe your general scope of work for Mr. Gish during that time?
I started off with answering phones, capping out jobs,
doing the social media. And then as time going on, as I learned more, I was handling payroll if it was needed. And then I did an insurance audits once the other secretary left, and I kind of took over.
Okay. Did you have access to Mr. Gish's financial accounts during that time?
I did.
Did you have access to his business financial accounts during that time for
I did.
Twisted Concepts LLC or At the Top Restoration LP?
I did.
Okay. And how do you know Mr. Marcus Hadlock, who's here today?
He was Gary Gish's former partner.
Were you working in that capacity for Mr. Gish during the time of Mr. Hadlock being bought out of the businesses?
I did.
Were you involved with any of the business decision making about any loans being taken out for the business?
I was aware of them, but I was not in the room when they were presently done.
How were you aware of those?
Mr. Gish told me that the businesses were getting loans.
I'm not asking for what Mr. Gish told you. I'm asking what personal knowledge do you have?
I knew that Amelia did the business loans for them.
Who is Amelia?
That would have been the other secretary.
Is that Amelia Andrews, the bookkeeper?
It is.
Okay. Ms. Hunt, did you receive mail for Mr. Gish?
I did at the office.
For him personally or his businesses?
There was both at one point.
Was it that same time frame from 2017 to 2024?
Yes.
During that time, did you receive any notices in the mail regarding an SBA loan?
We did.
Okay. And what did you do with those notices?
I would hand those to Mr. Gish because he needed to take care of them. That was his responsibility to take care of those.
Okay. Do you have any personal knowledge as Mr. Gish's secretary with access to his personal and financial business accounts for businesses, whether he made payments toward this business loan or not?
He did not.
Okay. How do you know that?
Because there was no money in the bank accounts. There was times where the businesses weren't doing like roofs or anything to make money.
Did you have any personal knowledge of whether the businesses had assets to pay certain debts?
What do you mean by that?
Did it own anything? Equipment, materials, property?
The businesses, if there was a roof, there would be materials to be bought for both of them, for the wrapping and the roofing. Is that what you're saying?
Yes. Do you recall, Ms. Hunt, whether Mr. Gish or his business Twisted Concepts LLC received money from an SBA loan?
Yes.
Do you have knowledge of what that money was used for?
I know part of the money was used to buy Mr. Gish's house, and I believe he used the other part of the money to buy a tree business.
Okay. And how do you have knowledge of that?
I was told about it by Mr. Gish that he was doing it.
Again, we're not asking. We don't want to know what Mr. Gish told you. How do you have personal knowledge?
Through the bank account.
Okay. What about the bank account? Did you see where money was going?
I could see where money was going and where it was not going, and Mr. Gish would get draw checks for money.
Is it your testimony that Mr. Gish received past due notices from the SBA for this loan?
We did at the office.
Do you recall if that mail correspondence had Mr. Gish's name personally on the envelope or whether it was directed to the business Twisted Concepts?
They were directed to the businesses.
Okay, we say businesses. Is that Twisted Concepts and At the Top?
Correct.
All right. Ms. Hunt, do you have any personal knowledge about the circumstances of Mr. Hadlock's buyout?
I knew about the separation agreement.
What about the separation agreement?
There was a time where I had to read it, and to my knowledge, in the separation agreement, that Gary Gish was taking full ownership of any of the loans that the businesses had.
Okay, when you said you had to read them, what do you mean?
Mr. Gish had me pull out the separation agreement and read it to him.
Okay, do you recall when that was?
It was in 2023, I believe. We were at the office.
Okay. And do you have any personal knowledge of Mr. Gish or anyone else with the business entity Twisted Concepts LLC making payments toward this loan?
No.
Okay. Tender the witness, Your Honor.
So you stated that with was it the Twisted Concept LP SBA loan? He used some to buy his house and he used some to purchase a roofing company. Is that
No.
correct? No.
The
Okay.
roofing company was already established.
So then what company did he buy?
Bought a tree company.
A tree company. And when was this loan taken out?
I was not in the room when the loans were the paperwork was filled out, but I believe it was in 2020 or 2021.
Okay, so you're not sure exactly when.
I don't know exactly the exact date of it.
And all of the SBA statements, letters, anything concerning the loan came in Twisted Concepts LP name?
They came in the business's name.
Business's name. So not in anybody's personal name.
No.
When's the last time you had any contact with Mr. Gish prior to his passing away?
I received a phone call from his son and Mr. Privet stating that if I wanted to talk to Gary, I probably needed to call him right before a couple of days before he passed away.
Okay. And prior to that?
I was his home healthcare nurse. I took care of him.
Okay.
He lived in my driveway.
Up until when?
I want to say 2025, maybe. I took care of him.
Okay, thank you.
You're welcome.
Redirect briefly, Your Honor.
Good.
Ms. Hunt, you testified previously that you had knowledge as to whether or not the businesses owned assets, correct?
Correct.
Okay. Remind me, are you still involved with those businesses as of today?
No.
Okay. When was the last time you were involved with those businesses?
The last time I was involved was when Gary lived in my driveway and he would have me log into the sales and use tax to pay those. And that would have been 2024-ish.
Do you have knowledge of whether Mr. Gish or his businesses have any assets that could pay debts such as this SBA loan?
Yes.
Okay. Tell me what assets are there.
Tree business has a C45. It had a skidster. It had a tree company truck. I know he had a lot of tools that were some bought from the business accounts with Snap-on. He would use the business cards to pay the Snap-on truck. Twisted Concepts owned a printer and laminator that could have been used to pay off prior debts.
Considering all of the assets you've listed and anything else owned by the businesses or Mr. Gish personally, is it your understanding that let me rephrase. Do you believe Mr. Gish and these business assets could fully pay off this SBA loan?
Oh, yes.
Of over $500,000?
I mean, not over $500,000, but I think his house and his assets and all could pay part of it.
Okay. I want to keep separate from the house. Other than the house, just personal property of Mr. Gish, personal property owned by the businesses. Twisted Concepts are at the top restoration. Are there assets that you know of that are valued at $500,000 or more in total?
No.
Ms. Hunt, do you know who Jerry Privet is?
I do.
Okay. Who is Mr. Privet?
Mr. Privet was a salesman for At the Top Restoration.
Okay. Were you aware that Mr. Privet was Mr. Gish's power of attorney prior to his death?
Not prior to his death. It was after his death that I was aware that he was his power attorney.
And you're aware that he's the executor of the estate that's before this court?
I am now.
Okay. Did you have any conversations with Mr. Privet about the SBA loan?
No.
Do you know if Mr. Hadlock had any conversation with Mr. Privet about the SBA loan? Okay. Do you know if Mr. Privet had any personal knowledge about the existence of this loan?
No.
Okay. No further questions, Your Honor.
Thank you, ma'am. You may step down.
Thank you.
Any other witnesses?
Creditor restaurant.
Do you have any proof?
No, Your Honor.
This court is limited to ruling on the validity of the exception to the claim based upon the nature of the claim itself. The claim was filed, and this is the language that is used in the claim. Marcus Hadlock filed a claim form on March 19th, 2026, and it's dated 3/3/2026, SBA COVID EIDL loan obligation, $753,424.66. That is the nature of the claim. It does not reference any other business debts that may have existed between the two of them. The claim is solely for the unpaid nature of the unpaid SBA loan. Then the court looks at these exhibits, and I understand there were different things, but I am referencing Exhibit 3, which was the debt obligation agreement these parties signed. And I agree with you that there may be some dispute among the documents, but this document is very clear. It is a debt obligation agreement, and it references, unlike the other documents, this one specifically references the small business loan, small business association loan in the amount of $500,000, and that both parties are bound to repay half of that debt each, with the intervener, or the claimant rather, Mr. Marcus Hadlock receiving an obligation of $229,934.97, and Mr. Gish having an obligation of $254,560.14. Now, how much we've got a $500,000 loan that's now increased in value, according to this, $253,424 in interest, perhaps. But this document clearly makes it, as I referenced earlier, the assumption by the estate, no liability by the other party. In the event one of the parties were to predecease the other, Mr. Gish having predeceased, the surviving party, which is Mr. Hadlock, shall not be responsible for the deceased party's debt obligation on the subject loan. What is the debt obligation on the subject loan by the deceased party in this case? Mr. Gish had a $254,560.14 obligation. If in fact that's the basis of it, Mr. Hadlock had an obligation to pay his half. And at this point, the court finds that the claim of Mr. Hadlock would be limited to $254,560.14 plus accrued interest on that amount under the SBA loan, and that there's insufficient information in this record, insufficient evidence, if in fact there is evidence, that there would be substantial assets enough to pay that loan rather than to bring the real estate into the estate. So the claim is allowed as to the amount that I have stated. It is denied the petition to bring the real property in.
Your Honor, may I clarify quickly? Is that claim to be paid to the SBA or to Mr. Hadlock?
It would be, that's a good question, because it really does, it's an obligation that Mr. Hadlock apparently has because he signed off on the SBA loan. And it was under this term of this agreement, it was to be paid by his portion was to be paid by Mr. Gish. So the court is of the opinion that when it comes time, I've allowed the claim, but the payment of that claim would be reserved for a determination after as to who is going to be receiving it. It would obviously seem to go to the Small Business Administration to satisfy Mr. Gish's obligation. Correct. Mr. Hadlock would still have his own. That then concludes the business before the court, so we are going to stand adjourned.
Thank you, Your Honor.
All right. Court's adjourned.
You want to draw the order? You gonna draft the orders?
I can.
Okay.
I guess I'm the one that made us took half a day.
Yeah.
found it? Oh, that's the.
Oh, no. Yeah, I've been back to Wiggins. It sounded like I was blasting through the.
Well, it may be loud here, but it's not.
We were
Oh,
That's the most important part.
Yeah.
The amount you just gave, 250.
What'd you do with it?
See?
This is our cheer.
254.
Plus 254, 604. I think I'm getting hit from both of them. That's what's happening is they're both blowing in this direction.
Up a degree and 67 now. 67.
What was it, 66?
It was 66 and Rob up to 70.
Well, let's hope that bump it up to about 71 or so, and let's see if that helps it for tomorrow. I got a long day tomorrow, I fear, so I'd like to not freeze my rear end off. You got any duct tape? You can just duct tape.
Well, I'm thinking the outside ones, if you look at the top 3 or 4 and point it down, but if somebody got on the ladder and pointed them up and put the point down.
Might be. I don't know.